Who's this?
Right, good morning. It's 10 a.m, so it's time to resume the inquiry. Just to confirm and make sure everyone's in the right place, it's an appeal made by Wayne Holmes North West Limited under Section 78 of the Town and Country Planning Act 1990 against the refusal by High Peak Borough Council of an application for full planning permission for residential development comprising 92 dwellings, including areas of public open space, landscaping and associated works at land to the south of Dinting Vale, Glossop, and that's SK 13 6NY. For anyone new today, my name's Gareth Wildgoose and I'm a Chartered Town Planner and the Planning Inspector appointed by the Secretary of State to hold this inquiry. This is day 2 of the inquiry, and firstly, the usual reminders. If anyone's got any mobile phones or electronic devices, please can you switch them to silent, please? That includes email notifications, if possible. I'll just give everyone a moment for that. And then just to confirm that I'll aim to break for lunch typically around 1 p.m. With suitable breaks at appropriate times in the mid-morning and mid-afternoon. There is a programme that you may have seen as you entered, and that's also available on the inquiry website, that sets out a broad programme that we're looking at, but we may have a brief discussion in the housekeeping before we get into proceedings just about the inquiry programme and how that may change. So it is only provisional and it may be updated. If it is updated, I'll confirm that and I'll prepare an updated version if there's any significant changes that will become version 2. That hopefully will then be posted on the inquiry website, and then if possible we'll get some printed copies for the room, so for certainty of that. Now, just in terms of the venue today, there is you may have noticed as you came in on the desk just before the entrance, there are 2 sheets. There's a parking sheet. If you've parked in the hotel car park, then you need to put your registration details on that sheet to make sure that you won't incur any charges. And also there's a separate attendance sheet. Now that attendance sheet is purely for the purposes in the event of a fire, for the assembly point to check everyone has got out safely. Now, on that particular note, can I just ask the council if they can confirm the emergency evacuation procedures and whether there's any fire drills or planned today, and where the
yes, no change from yesterday. No drills planned. Follow the green escape signs, and as before, the door behind you is probably the best one. Out there, turn left, assemble on the car park, where I'll count you all.
Thank you. Now, yesterday we had the openings, and then we heard from interested parties, primarily on highways, but some other issues were raised. We then heard evidence from the appellant calling a witness on highways, who was also subject to questions from both the public and myself. The intention today is to start with a session where the appellant calls a further witness on civil engineering and access, given the linkage to highways, and then after, presumably we'll have a break after that, and then once that's complete there'll be an opportunity for further statements from interested parties. Now, so on that particular point, before we get into housekeeping matters, I wonder, is there anyone in attendance who wishes to speak in that session today? Okay, I'll take it from the left then, please. I'll just make a note so that I call you in order. Yes. And are you a local resident or representing? And I presume you're opposing the development? Thank you.
Taya Darrett, T-E-Y-A-H.
T-E-Y-A-H. Yep.
D-A-R-R.
Yep.
O-C-H.
Thank you.
I'm a resident of Simonley, but I'll be reading a statement on behalf of another resident who's my husband who's at work today.
Okay, that's fine.
Mr. Miskell,
Yeah.
and I'll be reading a statement on behalf of the residents who unfortunately can't make it.
Thank you, Mr. Miskell. So,
Councillor Adrian Hopkinson.
were you representing Councillor Hopkinson?
Pardon?
What area do you represent Councillor Hopkinson, just so they know?
Old Glossop.
Thank you. Okay, and everyone wishing to speak is opposing. Is that correct? Obviously, there's two statements to be read out that presumably won't be subject to questions because they're not your own statement. For those who are giving evidence on their own behalf, are you happy to answer questions from both the appellant's barrister and myself?
Sorry, can I just ask, because I'll be reading the statement out on behalf of my husband, but as a resident and his wife, I'm in full support of the statement.
Yeah.
And I'm happy to answer questions as a capacity as a resident of Simonley.
Yes, you're entitled to give your own evidence as well as the statement, and if you're happy to answer questions on your evidence or it's taken as your evidence, that's absolutely fine. The only difference with answering question is it gives it greater weight because it's then been tested.
Yeah.
Okay, thank you. If there's anyone else who arrives and wishes to speak, I will ask before the session commences, but I will call you in. I'll try to call you in the order that I ran through there. So I'll keep a note of that. Thank you. Now, moving on to housekeeping matters, we did briefly discuss at the end of yesterday possible changes to the inquiry programme, including bringing forward, or at least having a witness in reserve to bring forward from tomorrow, depending on the progress today. Yes. Does that remain the position, and are you happy for that?
That remains the position. So those behind me have arranged for Mr. Tavendale, who's the arboriculturalist on behalf of the appellant, is anticipating arriving around lunchtime.
Thank you.
Which should provide us with a degree of flexibility if we get there.
Yes,
I
would have thought that if we do get to the point of calling the witness, it would be in the final
yes.
session today.
Yeah.
It's whether we have enough time. I'm not going to rush through the evidence on the basis of calling an extra witness, but just having one in reserve for that potential. Just to confirm to interested parties giving evidence, you do have the right to ask questions, and I'm presuming Mr. Barrett's happy for any of his witnesses to be subject to questions from interested parties. We did have those questions yesterday from the floor, and we had a few technical problems with with the microphones being able to pick up people asking questions. So if you are asking questions of witnesses once it's invited in, just bear with me so that I can relay your question in a way. It may summarise it, but hopefully in the right tone, so that it can be picked up on the microphone, so that people who are observing via the live stream can not only hear the question, but they then get to hear the answer as well. It was just drawn to my attention yesterday, so just in the interest of people being able to observe. Mr. Miskell?
Obviously, we had the highways engineers speaking yesterday afternoon, unfortunately, myself and the other residents had to go commitment picking children up, you know, getting notes from neighbours and that. So we've missed that opportunity to question the highways engineers.
The witness was only available yesterday. Obviously, there's opportunity for questions, and I asked my own questions in terms. So the evidence was tested in detail. Obviously, if there are questions that you have remaining, if you when you're making your statement, you're entitled to do so, to raise those questions. If they haven't already been answered, that will be a matter for the appellant to deal with it in evidence how they wish to do so. It may be the case that it's dealt with in writing afterwards in response if there's any outstanding questions that you raise for the highways engineer. That's absolutely fine. That question can be dealt with via written response should it be necessary. Okay. I'm just making a note of that. Okay, is there anything further?
I just wondered,
Yes, Miss Greengrass.
I'll have to leave at lunchtime.
Okay.
Is it possible to be able to give my statement before that?
Yes, I'll be calling you first, and it'll be immediately after the first break. So we'll deal with the evidence on civil engineering and access. Take a break as soon as that and any questions and my questions have been dealt with, and then we'll be straight into statements and you're first up. So I anticipate that will be well before 12. Okay, thank you. Okay, in terms of carrying on with housekeeping matters, so in terms of the programme, we've talked about the witness. The other matter that was raised in housekeeping in terms of the programme specifically was the possibility of virtual closings to reduce the use of the venue on Wednesday next week, which is standard practice because it's purely the closing statements from the council and dealing with the cost application, where obviously there are no questions from either myself or from any other party at that particular point. So I'm not completely averse to considering that as an option. Have the parties give it any more thought and whether?
So we haven't given it any more thought on the basis that both my learned friend and I are seeing how things develop, because it may be unnecessary. But the way that we're putting it to you, sir, if that would be a sensible option, if that's where we'd got to in terms of evidence and dealing with the conditions and the section 106, if all that had been completed, then it seems to me it would be prudent to have the session virtually in terms of closing for the reasons that you've just given.
Yes. Well, when would you be looking at closing? Would it be on the same day as in the current programme on the Tuesday?
I'd be happy with the current programme, but there's a bit of flexibility there. I'd be able to do that without any difficulty.
Yeah, I mean, I would be able to, I'm sure, close on Wednesday morning at 9:30 virtually, for example.
Yes.
If we haven't, by some other method, managed to close on Tuesday afternoon.
Yes, well, we'll see where we are at that particular.
But my first choice would be to close on Tuesday afternoon.
Yes.
My second choice would be to close virtually on Wednesday morning.
Right. Okay. The one thing I'd request is just to facilitate that option for the Wednesday, if that's the scenario that ultimately occurs, would be if the council could just make the necessary arrangements for that to be an online meeting.
Yes,
and
we'd send the invite round.
Yes, and if there's any way of making that available live streamed as well, so people can observe it or in some form, or would it be an invitation?
I'm sure. Yeah, we'll be able to
to look at the technical options of what's feasible.
We'll be able to do this, sort something out.
Thank you. And then the other thing was there was a pending document, and I noticed it was Mr. Bennett, but I don't think he's here this morning. I don't know whether he had any correspondence.
Yeah, we've got it.
You've got it.
And so that's the inquiry documents list on the website says will be available soon.
Okay.
And it says, and it is now arrived.
Has everyone got a copy circulated?
It
Yes.
will now be uploaded.
Thank you.
Thanks. How many have you got?
So that's ID 6.
That's ID 6, yeah.
Thank you.
So the only one that's outstanding is ID 8,
Yep.
which is the text of Councillor Starkey.
Yep.
Councillor Elliott Starkey. We have now, I think, got that text.
Yes, we're just waiting for the print.
We're waiting for it to come back from the printers.
So if you can confirm that immediately after the break, just before
Yeah.
the statements, and then we'll take that as inquiry document 8. So
That's
we're,
right.
we're up to inquiry document 7 so far.
That's right.
That's fine.
But and I think that's all that so far we were expecting. So everything is on track, housekeeping document-wise.
Yes. The only other matter is the conditions and planning obligations, which is my task to provide some comments. The conditions fairly relatively simple because I'm not expecting any significant revisions at this stage. There may be revisions once you receive my comments before we get into the discussion. But my comments on the conditions are now broadly complete. I just need to check them. So you're likely to receive them by tomorrow at the latest. They will be. I will include them as an inquiry document, so they're available for others to see. So it's publicly available. The planning obligations are a little bit more complicated because I understand that negotiations were still ongoing all day yesterday. So I haven't done any significant work in terms of providing comments to avoid abortive work effectively. Just for clarity for interested parties, the work that I'm doing is to provide some initial comments to kind of guide the roundtable discussions because the conditions documents are quite lengthy. It's good practice for parties to have sight of where I may have concerns or questions in advance, so that it can focus the discussion down on things that may need to be resolved, or can allow the council and the appellant to work together to provide an agreed list of conditions revised for me to consider. As I said yesterday in the opening, the consideration of the conditions and the planning obligations is standard practice. It does need discussion. It doesn't mean that I've made up my mind. It's just those matters have to be discussed in the event that planning permission is granted. And for every appeal that goes to hearing and inquiry, those matters are discussed, whether an appeal is allowed and planning permission is granted, or an appeal is dismissed. So it's just common practice that's undertaken. But like I said, I'll provide my initial comments to scope down and comments and queries. Hopefully by tomorrow morning I'll send it via my case officer, so the parties should receive it and then upload it as an inquiry document. We'll give it the number that's relevant at the time. But in terms of the planning obligation, are there any updates in terms of negotiations and/or whether a revised version may head my way?
So it will be heading your way. We had some very constructive discussions with the local planning authority yesterday afternoon, and we think there's a way of resolving it inter partes. Solicitors are working on the draft, and that I believe a copy is now with Ms. De Bruin. As soon as she gets an opportunity to look at it, because she's obviously assisting my learned friend at this inquiry, we're hoping to have comments back. It's work in progress, but I think our chests are approaching the finishing line.
Yes, I understand. In terms of worst case scenario when I might receive it, because I'm just thinking to programme my own work in on it.
So if you're happy to receive the working draft, I think you could have it around lunchtime or shortly after lunch, certainly by the end of today's business, and that may well be an agreed version. but we can certainly get you the working draft, and I think it'll be dotting I's and crossing T's thereafter, because the principles, I think, are now broadly agreed.
Yes.
Yes.
I would agree that the principles of what we're seeking to achieve were agreed yesterday. What's left is some double checking to make sure that, to coin a phrase, the 106 does what it says on the tin.
Okay. So is the end of the day from the council feasible then? I wouldn't want to push you soon.
I would have thought so. If, as my learned friend says, it's either in Mr. Bruin's inbox or on its way, and at the moment we think it must still be on its way,
Okay.
then we'll be able to multitask over lunchtime.
Yes. Well, if I say it doesn't necessarily have to be received in the room, but if it's sent via the case officer with hard copies by 6 p.m. tonight, with hard copies to be provided tomorrow morning,
We'll sort that out.
That would be fine, because that would allow me to work on it potentially tonight.
Yeah. Okay.
Okay. Thank you. I don't have anything further on housekeeping unless there's any queries and questions on procedure from the floor at this stage. I will run through the process of giving evidence and the approach to questions, etc. Before the next session commences. Okay. So in that case, we'll move back to the appellant, and if you could just call your next witness, please.
I'll be calling Richard Nicholas, please. Will you take that with you? It's inquiry document 6.
Yeah. Could I just ask whether or not there are any documents that my learned friend thinks we ought to have available to us or open?
The only document that I think might be relevant is CD 2.7, but it's dealt with in the evidence. I wasn't going to turn to the document, but if you wanted to have it by your elbow, so to speak, CD 2.7 is a technical note that deals with two issues, local flooding, and it also deals with the issue of gradient.
Yeah.
Mr. Nicholas, let me introduce you to the inquiry. You are you are Richard Nicholas, is that correct?
That's correct.
Civil engineer and a director with Betts Hydro Limited, an engineering consultancy since 2015. You have 20 years of experience in the construction industry across a range of sectors, including commercial, leisure, residential, healthcare, industrial, retail, utilities and energy, and you provided expertise on projects in the fields of road design, infrastructure design, tunnelling, flood risk, hydrology, hydrogeology, sustainable drainage, river modelling and nutrient neutrality. Is all that correct?
That's correct.
In terms of your academic qualifications, you have a Bachelor's Engineering degree in Mechanical Engineering, Energy and the Environment, a Master of Science degree in Water, Energy and the Environment, and a Master of Business Administration degree. You're a member of the Chartered Institute of Water and Environmental Management and a graduate member of the Institution of Civil Engineers. Is all that correct?
That's correct.
At the end of the introduction to yourself, you confirmed that the opinions that you are providing are your true and professional opinions, and they've been prepared in accordance with your professional institute. Is that correct?
That's correct.
Turning section, for the avoidance of doubt, if people want to see what we're looking at, it's Appendix 2 to Mr. Roberts' evidence, because he appended the report that you did. Is that correct?
That's correct.
So if people want to see the hard copy, that's where they can find it. You address in Section 2 third-party concerns, and the principal concern is the access road gradient. Is that correct?
That's correct.
At 2.5, well, actually you quote then at 2.2 a range of documents, and you highlight at the top of the following page, site access comment, the topographical survey and geo-environmental report confirm significant gradient of the site access of between 1 in 3 and 1 in 5. The DSP remains the local design guide and requires 1 in 30 for the first 10 metres for a priority junction. It also applies different gradients for footways and cycleways, but in summary says 1 in 12 maximum. The application also needs to consider inclusive mobility, LTN 120, both of which address key considerations to promote active travel and ensure that persons with protected characteristics are catered for. At 2.5 and 2.6 you deal with the detail. If Road 1 was at the gradient of 1 in 20 from the new junction with Dinting Vale, A57, then it would be approximately 8 metres too low to tie in with the existing levels at the existing vehicular access crossing the site serving the existing dwellings. Is that correct?
That's correct, yes.
You produce a plan later on which we can see that on.
That's correct, yeah.
You say, in addition, there is a private gas main under the existing vehicular access crossing the site, and the cover to this asset needs to be maintained at approximately 1.2 metres. And then you say 2.7, Road 1 at a gradient of 1 in 20 would also result in a huge amount of cut due to the existing topography and will result in the need for both retaining structures and extensive earthworks. There would also be a more significant impact on the woodland area and the trees resulting from that would result in further significant loss of trees. Is that correct?
That's correct, yes.
The solution that's provided is over, you have a 1 in 10 gradient over about 156 metres. Is that correct?
That's correct.
And it's right that there'll be no access to or from that road. So
Correct. It's an uninterrupted length of road.
Yeah. And 1 in 30 for the 10 metres from Dinting Vale. So as vehicles come or enter the new access, there will be a 1 in 30 gradient at that location.
There will, in addition to that, there's a transition curve, so there's actually an extra length of more level grade than 1 in 10.
Right. Would you take up document ID 6, which my learned friend distributed a moment ago? And this is an extract from the British Standard, is it not?
Yes.
So, sorry, Mr. Barrett.
Sorry.
We can't hear anything, can't hear any replies.
Is it?
Can you hear me?
Is it pressed down your microphone, or is it up?
I'm not. It was up.
Right.
Yep.
We'll check. We'll just check the audio. The other option is if you want to come forward to the first row where you might be able to hear clear as well.
If I speak and project like that, is that okay? Can you hear me? Yeah.
Thank you.
Okay.
Happy to resume.
Okay. ID 6. We can see that the front sheet really is an exchange of emails between Mr. Roberts and Mr. Bennett. Mr. Bennett was a contributor yesterday to the inquiry, and the extract is page 23, I believe, of the British Standard. 5.8.2 gradient of ramp. A ramp should have the lowest practical gradient within the range 1 in 20 to 1 in 12. The gradient of a ramp flight in relation to its going should be no steeper than shown on table 1, and there is table 1. Well, first of all, would you put that into context? What is the purpose of the British Standard as you understand it?
It's a guidance document. It's a code of practice to try and be as inclusive as possible in terms of accessibility. That's the crux of it.
And if we look at your evidence, you are aware and draw attention to 210 in the context of High Peak, the Highway Authority considering an example for 107 dwelling development at Linglongs Road in Whalley Bridge.
Yes, that's correct.
And you see there's a reference to, it's in CD 618, but I think this reference is suitable for our purposes. The Highway Authority are saying this: the topography of the site in this case is challenging in terms of levels and will result in some street being steeper than what the County Council's design guide normally recommends for public highway uses. The 6C's design guide recommends 1 in 20 for adoptable estate streets to encourage walking, cycling for all future highway users. However, this would clearly not be achievable on some parts of the site. And then it goes on. It is, however, noted that the long section provided for Road 1, that the chosen alignment results in a considerable amount of excavation between chainage 65 metres and chainage 200 metres, up to 3 metres in parts. This results in a street gradient of 1 in 10. Whilst not ideal for new estate street design, the Highway Authority would find it difficult to resist given the general highway network topography in the vicinity. Just thinking in terms of the general highway network topography in the vicinity of the appeal site, would that comment also be apt in
Yes.
these circumstances?
Yes, it is.
212 then, consistent with the observation that we've just discussed, the Highway Authority, whilst you accept is not ideal, the gradient of 1 in 10 that we have over 156 metres or thereabouts, is that right?
Yes.
Is necessary for a portion of Road 1 to tie into the existing private access road serving the current dwellings and to continue to provide the appropriate cover to the gas main. The proposal is nevertheless the best that can realistically be achieved, consistent with the local plan requirement to take access of the A57. And is that your view, Mr. Nicholas?
Yes, that is correct.
Okay. Just a little. Now, can you go to the plan, please, in your evidence that is above 214?
Yes, I'm there.
And there's a couple of features that we can see there the existing ground profile in this section, can we not?
Yes, it's shaded in green.
Yeah. And if we see the red hashed line, that's a 1 in 20 gradient.
Correct.
And if one looks at that, one can see further along to the right the existing gas line.
Yes,
which
correct.
Is, you see the red triangle with the exclamation mark there, and the tie-in beyond that for the highway.
Yes.
So if we had a gradient of 1 in 20, it would actually, the highway, the access would actually be below the gas main and below the existing highway.
Correct. It would be approximately 6 metres below the gas main and approximately 8 metres below.
And so the solution provided here is the lowest that can be achievable in the circumstances. Is that, well, first of all, is that right? What I've
That's
just put
right,
to you?
yes.
Right. There's another issue that there was Mr. Bennett's concern, and can I ask you to turn up, if you would, CD 2.58, which is a technical note. I should apologise to my learned friend. Perhaps I should have asked him to look at this. CD 2.58 and CD 2.86. 2.58 and 2.86. When you're at 2.58, this is the issue of refuges.
Yes.
Mr.
If you could give my computer a moment to catch up, that'd be great.
Well, funnily enough, I'm having the same problem with mine.
It's quite a large drawing. I have that on the screen.
Would you turn to paragraph 12, please, of that? And does that make a comment about the provision of refuges for
It does, yes.
pedestrians or
and
other cyclists or
Yes.
users?
Any users of that footpath.
And then could you go to CD 2.86, which is a plan?
Yeah.
And I believe there are 3 refuges shown there. Can you just, they're actually not marked as refuges, but one can see that there's an indent, if you like.
Yes, a widening of the
A widening
footpath
of-
with a level area.
And just tell us, what is that intended to achieve? People walking or cycling up the gradient, what would they be able to do at that particular point?
It's essentially a level area provided to allow refuge for a period of time, whether it's you're carrying heavy shopping or you have a mobility impairment, and designed to still allow the cycleway and pedestrian link to be accessible.
I want you then to go to the final document, the final page, which is another plan showing the access, and then a circuitous route which would be able to achieve appropriate gradients. Is that right?
Yes, I'm just opening that now.
Sorry, Mr. Barrett, which documents are we referring to?
So it's a plan.
2.86 are we still on?
I beg your pardon, sir. I'm going back to the evidence. That's my fault.
Okay. Thank you.
Mr. Nicholas's evidence, the final page of which is a plan. And I think what was attempted here was to show if you wanted to achieve the gradients, they could be achieved, but there's a price.
That's correct, yes.
And the price would be that you'd have to have this in and out facility of the path. It would be separated from the access itself, but there would be a consequence on trees, would there not?
Yes, that's correct. By lengthening the link, we're able to achieve a slacker gradient.
Yeah. So you could achieve the slacker gradient, but the cost would be trees in the location of where those bends occur, a couple of chicanes. Correct? Correct. And for that reason, what was the decision made? What's the preference of Wayne Holmes, your client, in accordance with your advice?
Yeah, balance ultimately. So the impact on the woodland in that location was considered too significant.
Yeah, and the actual grading, you recall from the British Standard, really the maximum should be 1 in 12. I note from the technical note 2.58 that what it is, it's a gradient of about 1 in 11 or
1 in 11.4 to be specific.
Yeah. And refuges would be provided at about 15-metre intervals.
Yes, I've got the specific figures if that helps.
Well, let's have the specific figures. Don't take a Barrett stab in the dark.
33.5 metres to the first one, then 50 metres, 50 metres, and then 38.5 metres.
Thank you very much. Well, thank you very much, Mr. Nicholas. I have no further questions on civil engineering. Thank you.
Thank you, Mr. Barrett. Thank you, Mr. Nicholas. Are there any questions, firstly, from participants on the floor of the witness before I ask my own questions? Mr. Miskell, if you can direct it through me, like I said, and then I'll relay it just for the microphones.
As Councillor Behind stated, it was difficult to pick up what the expert was saying. So the way I've read it, or from what I've gleaned, I just need confirmation. Are we saying the access road to the estate will not meet the required 1.2 metres clearance over the gas main?
It will.
Just for the microphones, I'll relay the question. So the question Mr. Miskell is putting is, from his understanding, is it that the access road wouldn't meet the 1.2 metre clearance above the gas main? That's correct, Mr. Miskell. Yep.
The current proposals do achieve the 1.2 metre of cover necessary over the gas main.
As a minimum?
As a minimum, yes.
In relation to...
Sorry, Mr. Miskell, just hold back 1 second. I know it breaks the flow, but because the microphones we have to. So no, you're not doing anything wrong. It's because of the constraints of the microphone. I've got to relay the question because so that we can pick it up. So yes, through me through me now, please.
In relation to refuge, there again, I did not actually pick up the purpose for the refuges. Can you just re-explain?
Right. Thank you, Mr. Miskell. The question is, can you just explain the purpose of the refuges? Because I don't think your answer was necessarily picked up.
Sure.
In the audience. Thank you.
Yeah, the refuge areas are to provide an area where somebody with a mobility impairment or who's carrying heavy bags or something like that could pause on their way along that footpath without with a level, safe area where they could stand or sit. And I think the intention is to provide benches on those locations. Yeah, I hope that answers the question.
So, yeah, so in effect, what you're doing is recognising that the levels of this footpath are going to be quite onerous for people with impaired mobility to make their way up to the development. So we're talking about inclusivity here for people of impaired mobility. This doesn't seem that they're being fairly accommodated. You're stating by the fact that you've got to put refuges in, it's going to be quite arduous for them. And also, as well as regards, I know you're not involved in the travel plan, but if they're going to struggle getting up to the estate, how the hell are they going to get to Dinting Station? I don't know if you're familiar with the gradients onto that place, but it seems like we're looking at an increased reduction in inclusivity for the people of impaired mobility and the aged, because we will have aged people on this development. So one, that precludes, it's going to be difficult for them to get to their own homes. Getting back to it does promote car travel. They're not going to be able to do that gradient, walk down to the shops, bring heavy bags of shopping bags, so they'll probably go in the car. If they're going to go to Manchester or other areas using public transport, i.e. the Dinting Station, then we're going to drive to Dinting Station. It's not going to be able to walk it.
Thank you, Mr. Miskell. Mr. Nicholas has heard the full question, but to summarise, and I'll let you confirm, the concerns in terms of the question are about that it's recognising that it's a substandard gradient for accessibility, particularly for those with impaired mobility, and it may result in increased car use, and it's also questionable how residents may access other gradients in the area that may not have those refuges.
One more question. Obviously, because of our location, winters can be quite severe up here. Who will be responsible for the regular gritting and maintenance of the footpaths and also the road itself? I don't know if that's been factored in. I'm led to believe highways are not going to adopt the new access road. Reasons why, I'm not too sure of, so I don't know if you could enlighten me on that.
Thank you, Mr. Miskell. So the addition to that, and I'll let Mr. Nicholas answer the three questions together. The second question was about the severe winter, the need for gritting, who's going to be responsible for it, and the third question was in regard to the status of the road not being adopted by the county council and what the reasons for that may be. So if you can, I'm assuming that summarises each of the three questions. So I'll allow you to respond to each of those, okay. Please, Mr. Nicholas.
Yes. For the avoidance of doubt, the access gradients that are being proposed are not desirable. They're not something we'd ordinarily aim to achieve. We'd like a much leveller access, but we're fixed and constrained by the characteristics of the site. The site has to be accessed off the A57 in accordance with the local plan, and there's the existing levels at Adderley Place that we need to tie into. So we're fixed by those 2 points and the routing through that location. The existing gradients vary, but are in the region of 1 in 3, 1 in 5, and that's always been the case when the site was allocated. So we're constrained by those 2 fixed points. The road alignment maximises the opportunity to keep that gradient as slack as is possible within engineering constraints. At the same time, we've taken additional measures to try and improve the inclusivity. We've separated the footway from the road itself so that we've provided a slightly slacker gradient to the footway, which, as I mentioned, was 1 in 11.4, whereas the road itself is 1 in 10. We've provided the additional refuge areas, again, recognising it's not a desirable gradient, but it is fixed constraints that we have to work within. The second part of the question related to
yes, that's the first
ice.
question. The second one was to do with the winter.
Winter.
And ice and gritting, who's
Sure.
responsible for that.
Sure. It's still the developer's intention to offer both the access and the roads within site for adoption by Derbyshire County Council. As to the reasons why they may or may not choose to adopt the road, that would be something that they would need to comment on, not myself. We see no reason why it can't be adopted by the County Council, especially in view of the relatively recent Section 38 agreement for the Linglongs Road scheme that we alluded to before. For the avoidance of doubt, that has a much longer length of 1 in 10 road without any additional measures to improve accessibility. The footway is tight to the road. There's also 2 junctions encapsulated within that section of 1 in 10 gradient, and it's over a much longer length as well, approximately 186 metres. So our site is more preferable to the local authority from that perspective. It also includes a cycleway, footway that is distinctly separate from the carriageway itself. In terms of responsibility then for maintaining it, if in icy or winter weather, that would be the responsibility of the County Council. If the road was for whatever reason not adopted, then it would be a requirement under the management company that would service the site to keep that road in appropriate maintenance. I'll let you catch up for a moment, sorry.
Thank you. No, I'm there.
Okay.
Mr. Biscoe, yes?
Do you believe it's fair that the access for people of, say, active mobility, have their access compromised? Mainly, well, because of the constraints on the site, but also to the benefit of able-bodied people. It's like the minority are going to have to suffer so we can get this development through for the majority. Whichever way you look at, they're being disadvantaged. You're recognising that the gradients are going to be arduous, so you put in refuge points, which is another recognition, isn't it, of they're going to struggle. I don't find that. Is that acceptable? Do you find that acceptable?
Thank you, Mr. Miskell. Through me, please. No, it's fine. Through me, and I'll just relay that, Mr. Nicholas. Yes, it's just whether it's a fair approach to have for in terms of mobility, particularly for the access to that potentially make how Mr. Miskell perceives it to compromise the ability to access for those who are less able, in preference for those that otherwise are. And the fact that the gradients and the refuge inclusion is a recognition of that. That fair summary. Thank you, Mr. Miskell.
Pretty better than I did.
Thank you.
I can only really reiterate that it isn't a desirable gradient, but it is something that we are physically constrained by. It's requirements of the local plan that the access be taken from that location, and we've looked to optimise the accessibility and make it as inclusive as it can be. We've looked at alternative approaches, and the impact on trees is significant were we to look at slacker gradients because of the additional land take and the engineering implications.
Thank you, Mr. Nicholas. I think from the evidence and from the questions, I think I've got that point, and I think there's an understanding there that yes, there are shortcomings, and what the appellants are doing, what they perceive to be the best solution. Now it will be for me to consider whether that's appropriate. Mr. Miskell, one more. Just
one more.
Okay.
Question. In relation to perceived additional loss of woodland should we, try to make this access more accessible, as it were. Has that aspect been commuted to Derbyshire Wildlife Trust? That basically is a potential option. And also, will it have an effect on, obviously it will have an effect on any 106 agreement. Has that been transmitted to Derbyshire Wildlife Trust, that plan?
Thank you, Mr. Miskell, again through me. But the question you'll have heard it, but it's regarding the additional loss of woodland. I'm assuming associated to the alternative option that's in Mr. Nicholas's statement, which has been discounted. Whether that has been communicated to the Wildlife Trust, and in terms of what the impact will be, or I'm assuming, or otherwise you want to know why that judgment was made. Yes.
Yes, I'm not aware of whether or not it has been directly discussed. That
just into the microphone.
Sorry, that plan that is shown on the appended to the proof shows the extent of the land take that was discussed with Derbyshire in their capacity as Highway Authority, and the extent and impact of the earthworks associated with that solution. Whether they directly discussed that with the wildlife team, I'm not sure.
Yes, and that's fine. There's the option is before me, so
Yes.
it has been put before me in evidence, so it's something that I need to consider in terms of whether an appropriate balance judgment has been made in terms of the proposal relative to the discounted option, the degree of harm in terms of on the woodland relative to the degree of the degree of benefits in terms of accessibility, whether it strikes the right balance, and I'll need to do that. But if you've got a further question, Mr. Miskell, just as a follow up.
In relation to the spine road again, where it crosses public footpath 50, and we're talking about a ramp being installed, is it physically possible to install that ramp or that area which will restrict cars turning left or right down onto the footpath? Is it physically possible to install that without obstructing the footpath at any time? Because it's the residents' legal right of access over that, unobstructed, 24/7. Now, it appears to be, I cannot conceive how that ramp can be installed without obstructing their rights at some stage.
Thank you. Just to clarify your question before I put it across to Mr. Nicholas, you're referring to Adderley Place. Are you referring to the restriction measures to stop people turning onto?
Yes.
To stop people turning on. We did discuss this yesterday afternoon, and obviously I understand you weren't here. The discussion, it was with the highways witness, was that it would be the western section that will be most restricted, which is effectively the section that would lead to the residential property, the least restricted, sorry, and the eastern section that would be more restricted, which would be the section that would run from Adderley Place through to Simonley Lane. So there was quite a significant amount of discussion yesterday in terms of explored through my questions in terms of what that would mean. Basically, it would mean that based on what the witness referred to, would the delivery drivers and postal vehicles will be able to turn from the site into the western section of Adderley Place rather than having to go round out of the access and then through the Simonley Lane access to come down. But there wouldn't be any restriction on forward movement from Simonley Lane along the existing path that the residents use. The restriction in the site will be predominantly on those turning into that eastern section to prevent that from occurring. Does that help in terms of the question?
It helps, and it raises one or two more questions.
That's fine.
But it's the issue of actually constructing that piece of restrictive highway. At some stage, it will block residents' right of access. But more importantly, it is the only access for emergency services. and we've already stated this before, in the event of a fire and there's some works going on that footpath, what happens? Fires do not wait for a barrier to be taken down or a construction vehicle to be moved. Also,
No, that's fine, Mr. Miskell. Just to clarify for you to assist the question, there was discussion with the highway witness yesterday regarding the restriction and regarding fire appliances. Notwithstanding, we've not necessarily covered the construction element, which is your core question, but they did draw my attention was drawn to the swept path analysis that's within the highway's proof of evidence that shows, I believe it was a refuse vehicle, and the questions were asked whether that was equivalent to a fire appliance, and I was told that the reference vehicle was the longest long wheelbase vehicle, and therefore a fire appliance would be smaller and would maintain access through the restrictions. Now, the bit that I haven't heard, which I'm assuming is your question at this particular point, is what restrictions would be on the access while that access road would be constructed, and would it obstruct that route?
yeah.
Yeah.
Yeah, I mean,
So I'll relay that as a question, and then if
Sure.
Mr. Miskell's got a follow-up, I just thought it was helpful because obviously we have heard something, so I just relayed my understanding of what I was told yesterday.
Yeah,
That's not me accepting that position, but that's what I was drawn. That was what I was drawn to. So it's just to help you understand that particular point, Mr. Nicholas.
yeah, for the avoidance of doubt, this isn't a junction that I've been involved in the design of. However, there are often circumstances on blue light routes and other important access points where there's a singular point of access, and there needs to be an appropriate construction method statement so that access can be maintained for emergency vehicles. I can't tell you the specifics of that methodology, but that's something that would need to be factored in if it's the singular point of access for those residents and emergency vehicles.
Thank you for bearing with me, Mr. Miskell. And that, yeah, I'll come to you, but I believe Mr. Miskell's just got a follow-up. Had you on that particular point? Are you content with content for me to move on to someone else's question?
Well, I mean, I've seen this new design, and at no stage, I'm putting the objection. Half the residents been consulted, regarding this construction going onto the footpath. And I'm quite surprised because it does contravene our legal rights. We have access to the footpath, unobstructed, not diverted, down to Simmerley Lane, 24/7. And that right goes back to, I mean, we just had an archivist on it, looking at the 1800s. It's something we've enjoyed for years, but as I say, it's the only access, the delivery drivers, it's the only access to get the children to school. It's the only access, and I've experienced it. I waited over an hour for the emergency service to attend an issue I had because of a parked vehicle. It was just, and the officer, they thought they parked it fairly, and I couldn't have a go at them, but the neighbours had to hunt round and find the owner of this vehicle so the ambulance could come up and visit me, and I was an hour in agony. Now, it could have been an incident where minutes matter. A fire, a heart attack. A bust appendix. Well, yeah, I was walking around with a bust appendix for 18 months, but, that's another story. But I was in severe pain. And these are the things I don't think the council have considered. I don't think, obviously Wayne Holmes haven't considered. When you look at this construction, it's like it's just going to be magic. We've had no consultation whatsoever. And I think in one of the reports or one of the responses from Corrigan's, they actually state it's impossible to install this or any restricted facility without obstructing the footpath.
I believe that a diversion order would be required to move our access, block our access. And I think it was detailed in some of the documents that were submitted before in the original appeal. original hearing that Wayne House were not going to follow through with the diversion because they required the access to maintain their footpath.
Okay.
Perhaps, sir, I can deal with it to some extent because it's a legal
Can I just
matter.
sorry, Mr. Barrett, could I just relay the question just in case with the microphone? So broadly, the concerns are the lack of consultation for local residents in terms of the new design of particularly the restrictions and relating to the access road, the potential for loss of access even if for a temporary period, including for emergency service vehicles, with examples given of when problems have already occurred in terms of access along the route because of inconsiderate parking. And then the construction phase impact that it's considered impossible to install without obstructing the access, and that a diversion order would be required. Thank you. Thank you.
Well,
Very
we
much, Ms. Barrett.
don't need a diversion order because it's not proposed to divert it. It's what is done is dealt with under up and down the country, day in, day out, is when there is work in the vicinity of a footpath. The construction management plan will deal with that to enable that access will be maintained to the premises, and it will be for us in the course of discharging that condition to satisfy the local planning authority, who may wish to consult, they may not, but it's entirely a matter for them as to the contents of the construction management plan. The right to a footpath is a matter for enforcement by the highway authority, but there would never be, in the years I've been involved in such cases, never be the fact that there would be some work in the vicinity of a footpath doesn't prevent that work taking place. The right to use the footpath, the right to pass and repass along it, will be maintained. The other point about, you've almost demonstrated it yourself, somebody inconsiderate parking blocked the footpath. Well, that position would be vastly improved upon in the case where there's a construction management plan, because the parties, well, certainly my clients, will have to think through how they are going to maintain that access, provide facilities to enable people to continue to access their home. These developments don't take place with those considerations being ignored. We don't block people's driveways to private houses.
Mr. Barrett, through me rather than across the floor.
It just simply doesn't happen.
So,
If we blocked a private driveway, sir, that's buying litigation for Wayne Homes. We can't block a private driveway. And this is exactly why you have conditions dealing with matters, the fine detail, the fine grain matters, in a construction management plan.
Thank you. I've heard the respective views on that point. I don't think we're going to advance very little unless there's something specific that kind of takes me forward on that particular point. But you had a question, Ms. Greengrass?
It was just going back to Mr. Barrett's comment on not blocking driveways. I see how it's impossible to lay things like sewage pipes, which they're going to have to do from the development down to the A57, without, they're going to have to cross somewhere. They're going to have to put the road in to allow that crosses SP50. So they're going to have to put in a diversion to go round that, which will be diverting our right of access that isn't along SP50, which is what we have in our deeds, stating that we have a right of access from along SP50 to Similly Lane.
My client,
You do block driveways as well when you put in any infrastructure that runs along a pavement or a road. It will block somebody's driveway. Effectively, SP50 is our driveway, and we need to be able to get in and out, as do our visitors, as do emergency vehicles.
Thank you, Ms. Greengrass. Just to confirm, and it may not be necessarily helpful in terms of the construction element, which I'll go back to the witness and or Mr. Barrett as they may wish to respond. But we did hear evidence yesterday afternoon in terms of in terms of the development because of the western side of the access. And I'm not familiar with where you live. I'm presuming it is to the west of what would be the access road. That it would actually improve your access options ultimately. Now, that's when it's completed. That's not necessarily during the construction phase, because you would then have the option either to drive straight forward to Simonley Lane, or you would have the ability to turn left down the access road and use that access road as an alternative, because those manoeuvres wouldn't necessarily be restricted as far as I understand it, based on the evidence that I heard. It would be the eastern side where you could only access in forward gear because of the ghost islands and the bollards arrangements. But I will put your question now to Mr. Nicholas and or Mr. Barrett if he feels the need to provide clarity on the point. That in terms of the construction phase, there's an inevitability for putting in services such as sewerage and the construction of the road of itself, that there may be some disruption to the through access from Simonley Lane. And has that been thought about in terms of potentially mitigating, notwithstanding the construction management plan, what those potential options might be to be incorporated into a construction management plan?
Well, in terms of sewers, there are trenchless laying techniques that could be employed. There are other options rather than dig down open trench excavations from the surface. You could lay the pipes trenchless. Again, there would be a range of options to be explored in the construction management plan. The shallower surfaces like comms, again, the disruption's relatively minor, and they can be done in segments as well in terms of disruption. Maintaining access is key.
Thank you, Mr. Nicholas. Anything further on that point? Are you happy for me to reflect on it and consider?
It would
Ms.
just be
Green?
that we would need something to confirm that our access would not be blocked, that we will be able to get to work, we will be able to drop children at school, we will be able to get out in an emergency. We're having a similar query with the development at the bottom of the lane currently, and seeking legal advice on it. But it's essential when it's our only access that it isn't blocked, and we don't have standard work hours. We don't have people don't leave the house at 8:30 and get back at 6 o'clock. Everybody's to and froing during the day, so it needs to be available to us the full time, and we would need something to confirm that it wouldn't be blocked.
Thank you. Well, I can put that to Mr. Barrett from legal terms, whether there's any understanding of that. Just to confirm for the microphones,
in legal terms,
it's about maintaining access, as it's a single.
In legal terms, you have the absolute right to have the access that you currently enjoy maintained. And my clients, in the course of its construction management plan, no doubt the local authority that will be discharging that condition will be alive to the fact that there are existing residential properties there whose rights need to be maintained. And it's not just a legal issue, it's something that no doubt the local authority will want to be satisfied of before it discharges that condition, that local residents will be able to enjoy access for all purposes and maintain an emergency access. If I may say so, this happens day in, day out on development sites where there are existing properties that will be materially affected by the development of the area within which those existing properties lie, and they have to be accommodated. It's as simple as that.
Can I ask one of my own questions, because it seems a pertinent point rather than to return to it at this particular point? Taking the points raised forward, could it be a matter of phasing in terms of the access road being available before those services are laid, so residents have an alternative, or legally would that not meet the tests of maintaining that access along Simonley Lane?
it would meet the test, and there's no reason in principle, as part of the construction management plan, phasing could be addressed if that was considered appropriate and necessary. It doesn't strike me at this moment in time as something that is necessary, but no doubt that can be considered, and if that assuages the concern of local residents, then I'm all for it.
Yes, I was just asking for my understanding
Yes,
as well,
yes.
whether there are alternatives in the event that there was, even if it's short term,
Yes.
need to lay services, that if the actual access road was in place before those works occurred,
Yes.
that at least there would be a feasible option for residents to turn left from that western
Absolutely.
section and use the new access onto the A57 and or the new footpath, if that were to be in place at that.
Yes, sir, I agree.
Point.
My eyes were looking at the plan that's at the end of Mr. Nicholas's evidence, and so I think that's apparent from that plan that could be achieved. The access could be in place to facilitate that.
Yes, that was just my
Yes.
that was just my understanding, that, and whether it was a feasible option, and then thereby how that could potentially be secured via the construction management plan or some form of phasing condition.
Yeah. So it is feasible, and so for the avoidance of doubt, one might list as one of the considerations that's to be addressed in the construction management plan whether there's a need for phasing to ensure existing properties, the access to existing properties, is maintained throughout the course of the construction.
Thank you, Mr. Barrett. Anything further on that? Are you happy for me to consider the respective positions?
It was just the recourse. I think it's because we're having similar issues with the development at the bottom of the FP50 currently, where even during the demolition phase, they blocked our access multiple times with vehicles coming into the site, despite the fact that they said that they wouldn't. And we've been told by the council that it's a civil matter. It's not something we can call the police to get the vehicles removed. So it's something that is really, really important. That it's all very well and good to say in this meeting that absolutely it will be in the construction plan. But for us, it means that we can't get in and out, and neither can emergency vehicles, and neither can our visitors' deliveries or anything else, and it affects our lives. So this is why we're kind of drumming the point that it really is crucial that access is not blocked at all.
Yes, I think I can ask the parties whether there's anything to add, but I'm not sure that it took the point any further forward than the answer that I've already been given. Just for certainty, obviously, I've not made up my mind on the proposal as a whole, but in the event that I were to consider that planning permission should be granted and conditions were to be applied, these sort of issues would need to be addressed. And what the questions that I'm necessarily asking alongside your questions are for my understanding whether that would potentially be feasible. Okay, thank you. Any further questions for Mr. Nicholas on anything else before I ask my own questions? No. Okay, I'll move on to my own specifically. So, if you can just give me one moment, I'll just check through my questions to make sure that they've not already been answered in the course. So. Right. Yes, I've got three questions. I'll modify them slightly because I think some of the answers I've probably touched upon the questions that I had, and I've already asked one of the questions that I had in terms of maintaining access for residents. Just in terms of the gradient to the site access, it's my understanding from your technical note dated the 17th of May 2024, as appended to Mr. Roberts' proof of evidence, that the reduced gradient of 1 in 20, whilst not technically impossible, is unlikely to be feasible because of that tie-in that you've referred to, and established land levels further to the north, together with the gas main, and the potential extent and cost of associated cut into the existing topography, with associated retaining structures, earthworks, and resultant further significant loss of trees. Now, we've heard about the impact on trees. My assumption is that there's probably an addition in terms of the viability considerations as well, because I'm assuming there'd be from a civil engineering perspective, there'd be a considerably greater cost in terms of any particular alternative or any other form of routing that might be sought to kind of
That's correct,
slacken, using your words, to slacken off the gradient.
Yeah, you'd be introducing other hard features like retaining walls. There'd also likely be handrails and other features to allow that to be delivered. That would all have cost implications beyond that currently proposed.
Yeah, so retaining walls, additional excavation.
Yes. Potentially engineered slope stability as well.
And that's notwithstanding the impact on trees.
Correct.
Thank you. And then just in terms of avoiding harm, we heard a little bit from the highways witness yesterday in terms of the graduating of the slope approaching the access.
Yes.
But I'm conscious that there are interested parties here today who may not have heard that evidence. So just an understanding of how the slope, how obviously the use of curves, but in terms of at the access itself in terms of highway safety, or understanding of that arrangement and what the proposal is sought to achieve in that location.
Yeah. So the geometry of the junction itself, which should be included in the 278 works, are in accordance with the standard design criteria of Derbyshire County Council. There's a requirement for the first 10 metres from the channel line of the A57 to be at a gradient of 1 in 30. That's prior to then transitioning with a vertical curve.
Yes.
To the steeper gradient of 1 in 10. So there's a 20-metre vertical curve that transitions. So essentially the 1 in 10 starts approximately 30 metres from the channel line.
Yes, and that is consistent with what I heard from the highways engineer, and I did ask questions previously in terms of the traffic generation, in terms of use of the access, and there was much discussion about the 1 in 2, 1 in 5 movements in terms of the numbers per hour, so on, in terms of the queuing, and Mr. Roberts considered that there wouldn't be queuing, and in his view, the geometry was appropriate to account for the traffic conditions along the A57 and the access there too, and any level of queuing for both vehicles turning out, which he considered to be negligible, and for vehicles turning into the site, which again he considered to be what he considered to be negligible or uncommon. Obviously, I've heard that. I haven't reached a particular view on it, but I just wanted your opinion in terms of the suitability of the geometry for the local highway conditions that you've experienced in that location.
Yes, I've attended site on a couple of occasions to look specifically at the access arrangement, and it meets the requirements of the design criteria for an adoptable access. I think it was noted as well that speeds are constrained by the existing camera, and accordingly the necessary visibility is maintained. You mentioned the number of vehicles turning out before, essentially with 30 metres, or before you get into the 1 in 10, you could stack approximately 6 vehicles prior to going back up onto the steeper section of road. Don't know if that helps.
Yes, and
just to visualise
it. It's helpful to me in terms of understanding what that kind of, if there were a queue, and obviously visually, that's not necessarily what the highway witness said would happen. But yes, it's helpful to me to understand that particular position. Thank you. And in terms of my reference when looking at these different gradients, am I drawn to CD 617? I think that's the longitudinal drawing.
Yes, that's correct, yeah. That shows the existing gradients, the proposed gradients. It also indicates where the 1 in 20 gradient would be, which would be the more desirable gradient for the road centre line.
Thank you. Then onto the Linglongs Road example, and I've obviously heard, as part of your responses, you've covered this slightly. You consider it to be a similar example with gradients of 1 in 10 for more significant lengths and including junctions, which is different to the proposal that doesn't include any junctions on that particular section. The associated advice from the County Council on the scheme was provided as core document 618. In that context, can you just explain your views, how you consider it's comparable, having regard to the longitudinal sectional drawing? So, in terms of the details, are the 1 in 10 sections approaching the junction already within the site, or?
Very similar, actually. They're pretty much from the access. They similarly have a level junction on the primary access, and then fall at 1 in 10 into the site. The length of 1 in 10 is more extensive than our proposed site. I think it's 186 metres from the long section drawing.
Does it have any curves?
It does have curbs. It has standard height curbs. What they haven't done is separate the footway from the carriageway, which is an opportunity that we've taken to increase the length of the footpath to slacken its gradient. There's also no refusal rest areas. And in addition, it encapsulates 2 junctions, side junctions, both on the same side.
Yes, so I take it from that suggestion you consider that the proposal provides more mitigating effects.
It does, yes. That highway was adopted by Derbyshire County Council. Section 38 agreement signed in October 2023.
Can I just ask then, if that example has been offered to Derbyshire County Council, have they given specific reasons why they're taking a different view to the proposal?
Nothing specific in regards to Linglongs Road, no. It's still the developer's intention to design the scheme to a fully adoptable standard and to offer it for adoption. The concerns, as far as I'm aware, principally relate to the access gradients. However, they might take a different view of the fact we're aware a similar solution's been adopted recently.
And I presume that negotiations will be
Correct.
ongoing.
Correct.
I note the intent that the proposal is to create a road to adoptable standards, and
Yes.
and obviously it isn't necessarily a closed door in terms of adopting it. And I'm assuming the appellant may be pursuing that option through all the way through until to get a different answer.
If I can insist, sir, you anticipate exactly what my clients intend to do. It will be constructed to adoptable standards, and then we will pursue under section 38 the county council in order that it be adopted. Now, That's for the future, but it will certainly be built to adoptable standards.
Yes, that my understanding of the situation. That's my understanding of the situation. I was just probing that area because it does seem. I'd like to say unusual, but not necessarily unusual. But not. It isn't necessarily explainable when a different decision seems to be given. On two things that may be similar, and obviously, and be told it's similar, and the issue is obviously I don't understand. I can't really push you on what the background may have been to that development and the extent to which that was adopted via negotiation or not. So it may be the case that it was a similar process that was reached, but that's assertion rather than facts.
So I'm not inviting you to speculate, but we haven't had, if I may say so, a very clear explanation. Go higher than that. We haven't had an explanation for why they're taking a different view. That will be part of the reasoning why we will say you ought to treat cases on a similar basis, and without an explanation as to why they are taking a different view. That's one of the reasons will be part of the case under Section 38, why they should adopt it.
True, and I'm wary of treading into ground about consistency of decision, because that's something that often crops up in our role as independent decision makers. Things are a matter of judgment, but they are the same body in the same way. And yes, everyone seeks consistent decision making, even if it's not achievable in all circumstances.
Absolutely.
Thank you.
And they may have a reason that we're not aware of, at which point they'll have to make that case. So it is a matter that will have to be explored at another time, but for the purposes perhaps of our appeal, so you will be aware, one, it will be built to adoptable standards, and two, it's my client's intention that it be adopted. And I'm going to use the word fallback, but I don't mean it in the usual planning inquiry sense. That our fallback position is that the management company will have to be responsible for it.
And in terms of the management company, condition are 106.
Yes, it'll be dealt with. The arrangement for it is in the 106.
106, yeah. As you can tell, I've tried to avoid too much work on the planning obligation for fear that it may have halted.
Well,
but I will be looking at it in more detail once I've received the next draft.
Yeah, I think you're right to do so. So until you see one that's virtually completed, yeah.
Yes, no, I do have it, but I was loath to rely upon it when I knew that things were in negotiation. So if I do ask some simple questions that may have been answered by looking at it, I just appreciate that's why I'm asking. Okay. So, and anything further on that particular point? I don't have any other questions, because I believe the pedestrian access question that I had has already been broadly covered, and including that I had that question and I asked it as well of the highway officer in terms of the gradients and the refuge area, and that has been helpful to me to understand about those refuge areas a little bit, because I had a little bit more clarity in your evidence today than maybe the highway witness had. Understanding of what the purpose of those refuges and whether they would be flat or not. So, I thank you very much for your for giving your evidence, and thanks for taking the questions. Time is it's now 11:27. I do propose to take a break now until 11:45. I'm conscious of Ms. Greengrass's constraints, so we'll, as soon as we resume at 11:45. We will take comments from Ms. Greengrass. Thank you. The inquiry is adjourned until 11:45. Right, we're approaching 11:45, so if people could take the seats, please. I'll invite you up in. Yeah, just one moment. Okay, it's 11:45 now, so the inquiry is resumed. Just checking housekeeping very quickly. ID 8.
ID 8, indeed, sir.
Thank you very much.
Elliot Starkey's statement.
And have the documents been circulated?
That's already on the website.
Okay.
And 6 is taking a bit longer because it's 3 different sheets of paper that have to be put into one PDF file.
Thank you. That's okay. So I've got documents 1 to 8.
Yes.
Right. Okay. If there's nothing else at this point on housekeeping, we'll move on to calling statements for interested parties. So, Ms. Greengrass, if you're first, please. Just to confirm that you'll be giving your statement first and your evidence. So I will be making notes. So if you can just speak clearly, and I'll try and make those notes. Try and speak into the microphone so people can hear. Mr. Barrett will then get an opportunity to ask questions. If you can try and answer his questions with either a yes or no, and then qualify them. That's helpful and moves it forward. And then there'll be questions. There may be questions from me if there's anything that I need to query in your evidence. It doesn't always happen, but on occasion I may have that. But whenever you're ready, there's a glass of water there if you feel the need for it as well.
Thank you.
Okay.
Hi. So my name is Julie Greengrass. I'm a long-term resident of Adderley Place, having lived there for the past 16 years. I've worked from home for the last 12 years and been a dog owner. I'm a daily user of the fields at Adderley Place that have been put into this for this development. I'm also a frequent pedestrian, cyclist and motorist along the lane that crosses the land, which is FP50. Therefore, my connection with this area is really substantial and emphasises my personal and vested interest in the preservation and my right of access, as we discussed earlier. As is quite apparent, I object wholeheartedly to the development. And as we know it, the fields at Adderley Place are for the benefit for not only the residents of Adderley Place, but also for the benefit of Glossop residents and the wider area. And they are used regularly by Glossop residents as a shortcut or as a quiet way to walk through, rather than using the main A57 as a route to get from Dinting through into Simondley. I'd first like to state that when Adderley Place was first submitted into the local area plan, the council failed to consult with local residents outside of Adderley Place directly. We received a leaflet detailing that it had been submitted for review, but the surrounding area of Simondley and Dinting did not receive this information. We knew this because of friends and family that live in the wider area, and despite the council stating that they'd sent out over 3,000 leaflets, none of them received them. The residents of Adderley Place felt that this was important to the wider community, because at the time the proposed entrance point was not detailed and the FP50 Kestrel View in Simondley were also suggested, along with the steep access for the A57. As residents, we leafleted and knocked on doors throughout Simondley and Dinting, and with the help of councillors John Hacken and Julie McCabe, there was a public consultation held at Bradbury House in Glossop for the local area plan proposal. The response was overwhelmingly unanimous that nobody in the local area agreed with the build, citing traffic, loss of green space when brown sites were available, and the affordable housing, which was included originally in the local area plan, as we discussed yesterday. So now it's been removed, the proposal has become even more rejected too. Coincidentally, when we received the letters from the appellant regarding their plan to build on the site, again, Simondley and Dinting were also not consulted. So again, we printed leaflets and knocked on doors, and we can see from the amount of objections and from the petition that we put forward that this build is something that locals of Glossop feel it just doesn't make sense with regards to lack of infrastructure existing currently without the extra people moving in, the traffic, the air pollution, the loss of the last green space on this side of Glossop, and the loss of the wildlife that lives there. We feel that Glossop residents haven't been consulted or heard, and at the end of the day, we're the ones that we have to live with this. As we heard yesterday, the developer is proposing to consider that the 1 in 10 gradient at the lane at Adderley Place, FP50, could not be used as access for all pedestrians and cyclists due to the lesser gradient. Adderley Place is maintained by the current residents of Adderley Place to allow sufficient vehicular access. This is paid for by the residents and carried out by the residents, and has been for as long as any of us can remember. It's a tough job to keep on top of, long spells of wet weather, as seen over recent years, and especially this summer, causes the surface to degrade rapidly, as you'll no doubt see on Friday.
I am familiar with the site. I've walked the route already.
Yeah. Often faster than it's often faster than regular maintenance can keep up with. Because of this and the nature of the rough surface of the lane, it's often potholed, and as Mr. Bennett stated yesterday, would be inaccessible by wheelchair users and a struggle with a pushchair. Since living at Adderley Place, there's been a couple of things that may not be obvious to planners, developers, and possibly people that don't live there. If I have to attend a meeting or a place of work and dress smart, I have to take into account my footwear. Take a torch if I'm coming home after dark, for example, in winter, and have my wits about me. To get to the station, the bus stop, or to walk into Glossop, it involves walking up or down an access that is poorly lit, extremely slippery when wet, often overgrown with nettles, although I noted that I think the council has trimmed what we call Chip Alley, which goes down to the A57 down the side of number 1. Yeah.
The steps element.
Yeah.
I did navigate that route.
Yeah, it's fun in winter when it's muddy and wet and slippy and icy.
It wasn't great with suitable footwear at this time of year. Unsuitable footwear at this time of year.
Yeah,
so.
Exactly. Yeah, it's a bit of a, take your life in your hands as you go down there. I've slipped descending down that, and I'm not alone in that. Many don't use it at all for that reason. I recommend, well, as you said, you've already visited that site, but for anybody else that hasn't been there, to go and take a look at what we call Chip Alley, and you'll see what we mean. My other option is to walk down FP50 to get to Simony Lane, which is muddy, as it is a little bit at the moment, but I think it's in quite good condition at the moment. It's potholed, it's obviously not gritted in winter, and crucially, it's not lit. I make a judgment call on which is the best option when I walk back from Glossop at night or have to walk in. In winter, even in a walk into Glossop to the supermarket after work involves using a torch. I always worry about turning my ankle in one of the potholes that I can't see. I know that some of the other female residents won't walk down the lane after dark due to concerns over their safety. Traffic modelling for this site hinges around public transport links, therefore less car travel. However, the suggestion that Dinting Station is within 700 metres is actually laughable if they think it's walkable by everybody. This also admits that the station is also at the top of a very steep, rough surface, which we talked about earlier. The path is also inaccessible by a wheelchair easily, and those with a pushchair or a pushchair and trying to also walk with a toddler is virtually impossible, and impossible in heels. It's not gritted in winter, making it dangerous, and it's also poorly lit, and often the lights don't work either, and they take time to replace the bulbs. And I have actually walked to Glossop station, which is further away, rather than walk up there in the dark, because I felt safer. If the other option for residents of the site is to walk up another steep road, which is also tree-lined, there's also no housing on that road. After dark, for women, I think they would feel unsafe walking up there too. I question whether I would walk to Gamesley in the evening when it's dark, even along a lit footpath that runs up the side of Glossop Road, purely because there are trees along the side and I feel vulnerable. It was suggested yesterday also that if you live in Glossop, then you have to expect hills. And as Mr Bennett alluded to yesterday, the cobbles on FP50 and the potholes would make it impossible to use for those in a wheelchair or those that struggle to walk unassisted. I'd also like to make a point that we're an ageing population. You don't expect to lose your ability to walk, but it's a fact of life that many of us will at some point. It's not something that you can plan for, but you'd hope that the house that you own, which for some will be their last house, allows you to leave your estate under your own steam. And I feel that the accesses that are available to the residents of the new site will not allow that. One other point to note is that in Glossop, the pavements are not gritted. So even on Simonley Lane, the pavements are not gritted. So very often residents have to walk in the road or, take precautions. So it makes it unsafe again. And I feel, as we were talking about earlier, with the gritting of the access road, this could cause major issues. The other thing to bear in mind is that Adderley Place, due to its height and location, is always colder than the temperature on the A57 by a few degrees. This means that it holds onto ice and snow longer. I've walked down the lane in walking boots and full winter gear, yak tracks to avoid slipping, only to find that when I reached the A57 there was no snow or ice at all. Therefore, with FP50 proposed as the main pedestrian access, I believe that the development lacks adequate inclusive access for all residents. Moving on to Adderley Place and our access. Because the road crosses FP50 and it'll have to be raised above the level of FP50, it will create a ramp that will create a runoff that will cause a pothole to form either side of that ramp. This will be dangerous to pedestrians when full of water, as they all have no idea how deep it is. And also it will damage the vehicles of the residents and delivery drivers and their visitors. Will the appellant pay for the maintenance of this regular issue? Or is that going to be down to the residents of Adderley Place? Those exiting the estate will be travelling downhill also. This includes cyclists as well as cars. Who has the right of way? The residents of Adderley Place or those coming from the estate? Will there be road markings to avoid accidents with faster moving vehicles? Is there going to be a stop sign, for example, to stop people coming from the estates to allow us to go through, just for the safety aspect? Several of the residents have very low slung cars, sports cars, that will be a struggle to drive over any sort of ramp. And in fact, they don't take them out that often because of the hot potholes. We don't feel that this has been considered, and we could have brought this up as an issue had we been consulted. As discussed yesterday, the proposed solution to prevent the residents of the new builds using FP50, I feel, has not taken into account human nature. As detailed yesterday and this morning, it is possible for those exiting the estate to turn left towards Adderley Place to allow delivery drivers, postmen, etc. to reduce their journeys. If you're expecting one car to exit the estate every 2 minutes on average, this means that some of the time there will be more cars and a queue will form. Currently, to turn left out of Simonley Lane at peak times, you can be sat there for at least 5 minutes, as a constant stream of traffic coming from your right that rarely lets you out due to the speed that they're already travelling at in a straight line, similar to the exit point for the estate. And they generally hog the road, even when they're moving at a slow pace. What some people will work out very quickly is that they can turn left quite rapidly towards Adderley Place, turn their car around where we park our cars or in the driveway of Woodland View or Avening, and then exit via FP50 onto Simmerley Lane and out of Glossop via High Lane. I don't think that the private road signs will deter everyone. We have that currently. It doesn't deter anybody. Should this happen, the other point to note is that Mellor Homes' development of 10 dwellings that exit onto Adderley Place by the exit have been approved for development, and that build has not been approved on the base. It hasn't been approved on the basis of increased traffic from a new estate. Therefore, I would argue that this would compromise safety for pedestrians on the footpath, often children first thing in the morning, walking to school, looking at their phones, not paying attention, and contribute to rapid deterioration of the surface of FP50. That it will be virtually impossible for us residents to maintain at any sort of pace or actually to afford. Moving on to biodiversity, the site's been identified by DWT as having natural habitats of very high importance and qualifies as a local wildlife site under botanical, bird and invertebrate criteria. Due to the development, almost the entirety of the site, including valuable grasslands and other habitats, will be lost, moved to another site of lower biodiversity value. It is unlikely that the same invertebrate and birds will continue to be supported, as the habitats also will be a result of the surrounding habitats off-site. Currently, it's not been noted in any of the surveys, but there are breeding deer that are often seen by residents and locals that use the fields. There's been 3 successions of young deer over the last 3 years. We see them regularly, but it's not been listed in any of the reports because they didn't see them. I also noted that in the Derbyshire Wildlife Trust's most recent letter, they noted that they hadn't seen the bumblebee, which is also on the UK BAP list. Just because they didn't see it whilst doing a survey with a quadrant they don't scour every single centimetre of that land, doesn't mean it's not there, in the same way that just because they haven't seen the deer doesn't mean that they're not there. In the surveys carried out, it identified that there was also flora and fauna that were recorded on the site that are on the red list. This includes the buff-tailed bumblebee, as I just noted, and other grasses, due to very specific and unique conditions to thrive, which is why they're on the site already. This could be regarded as something that is difficult to also replicate, or why we're producing a site like that all over the place. Habitats are also born of wider environment, and this helps to create these unique conditions, e.g. the surrounding woodland, the other flora and fauna in the area, all contribute to how the land reacts. By moving the flora, not the fauna, to this new site in Chinley of lower value, the conditions will be different. I'm sure anybody that's a gardener who's moved a plant from one side of the garden to the other side of the garden, only to see it die, realise how easy it is for plants to not enjoy their new conditions and give up, in which case we would have lost the red-listed species that have been noted in that report. I've read through the 106 agreement and the Tetra Tech report, and I can't see any reference to how they will mitigate for the movement of invertebrates, including the bee. As an apiarist, I know how challenging it can be to move a colony of bees from one location to another, and also to contain them in your own hives. The bees will require a certain habitat. They can fly for over a mile from their nest to forage. If they are moved later in the season, as I think the proposal states, then they will have lost their stores and their safe overwintering habitat, and it's likely they won't survive. As residents, and I think this has been brought up in a lot of the objections, people can't understand why the site of very high BNG value couldn't be spared and used as an offsetting location for future builds instead of attempting to move species of high value that need specific environments to thrive to somewhere where they wouldn't normally be found. The council have also put in place a 2-for-1 tree planting policy, which is being replaced with an S106. The worry is that this could set the standard for future developments in the High Peak, which I believe goes against the government's tree planting targets and is a disaster for the town's ever-increasing carbon footprint, and all of which undermines the High Peak Borough Council credibility in tackling the climate emergency. In February, a TPO was also put on the land within the development. It's not listed anywhere, but the catalyst to this order was from residents of Adderley Place discovering surveyors on site in early February. They discovered that it was at the request of Wayne Holmes to assess the area for tree removal before the bird nesting season began in March 2024. It goes without saying that had this tree removal been carried out in February, this would remove one of the S106 payments and one of the original objection criteria from the appeal. Given the commitment of our High Peak Borough Council to prioritise climate change and address concerns relating to flooding, loss of natural environments and biodiversity, the preservation of the TPO area aligns seamlessly with these objectives. Mature trees within the TPO sequester substantial carbon, enhance air quality and contribute to the High Peak Borough Council's goal of carbon neutrality by 2030. With the A57 at Dinting Vale already under scrutiny for poor air quality, protecting these trees becomes a critical measure in improving and sustaining local air quality. The trees in the TPO create a vital habitat and cover for local wildlife. Users of FP40 often spot the breeding deer that I spoke about, utilising the trees for cover during their movements. Often people have seen them down as far as the church at the bottom and very early mornings crossing the A57 to get to the woodland on the other side of the road. Beyond the deer, nocturnal badgers, buzzards, owls, and during the summer months, swallows, pheasants and bats contribute to the area's biodiversity, whether nests here or whether they're using it for foraging. These trees constitute an essential ecosystem which allow wildlife to coexist with our properties, the main road and a popular footpath. Preserving these trees is crucial to maintaining the link between adjacent greenbelt areas and the land at Dinting Vale and Platts Woods, enhancing the benefits for wildlife. Failure to protect them may lead to habitat fragmentation due to this potential large-scale housing development, risking the loss of local wildlife and lesser seen flora and fauna. There's also the sensory impact of the trees, which is substantial to people in the area. With their density, it mitigates the noise from the nearby A57, which is really noticeable during winter once all the leaves have fallen. This contributes to a very tranquil and peaceful walking environment, promoting well-being and overall health for local residents and users of FP50 that divides the TPO area. The visual contribution of the trees to the landscape further maintains the area's character, creating a very rural atmosphere in close proximity to a very bustling town. And then finally, I've got some questions from yesterday and also questions that I felt weren't answered within the literature. Okay. So one of them was from David Roberts yesterday, and we talked about how Glossop needs more affordable housing. That's no secret. This enables that young people to remain in their communities, and it also offers downsizing options to others that also can remain in their communities. But with the lack of affordable housing, they have no option than to move out of Glossop to find housing that they could afford. The houses in the proposed build aren't for local residents. They will bring more people into the area from outside, putting more strain on local doctors, dentists, schools and roads, which are already at peak capacity. The local school has no capacity for new students. Does the transport statement made by David Roberts yesterday about residents of the new estate, the transport statement made by David Roberts yesterday about residents of the new estate walking to school with their children and not driving, take into the account that because the accommodation will not be affordable, that these will be people from outside of the area. Therefore, it's very unlikely that they will be able to get places at Dinting School, and they'll have to go elsewhere and drive their children. Also, there were documents submitted by High Peak Borough Council for development of the land adjacent to the main site, which offers Kestrel View in Simonley as an access, despite it not being viable. I think it's something like 25 houses are only allowed access along that type of road. Is there a possibility, if opened up for this piggyback build, that Kestrel View could be subject to the access of large plant to get to the Adley Place build, and also to become a possible rat run as a secondary exit point? Then, regarding S106, I read through the draft agreement, and it details some of the payments are to be made before commencement of the build, which is a good thing. However, the infrastructure payments are not detailed on there, or at least I couldn't see them. This is a concern for many Glossop residents as it regards doctors, dentists, roads, schools, etc. As I suggested, due to lack of affordable housing, the new houses will attract those from outside of Glossop, which will put extra strain on these essential services. Could the barristers confirm what happens in the event that the appellant can't sell the houses that they are building and therefore don't have the funds to pay for the S106 that they've committed to, which are quite extensive with this development? As an aside from that, in the Glossop area, there are a couple of developments that have stopped mid-build or are yet to start. Is the council happy that due to the lack of affordable housing that they won't sell? There's also the possibility of flooding once the trees are removed to build the access road. This could put the build on hold, and then we'd lose an area of beauty unnecessarily. The current residents will be stuck in limbo with a huge construction site on their doorstep, and we won't be gaining any housing, and there won't be any 106 payments. Overall, we'll be losing an area of high biodiversity value as well. That's everything for me. Thank you.
Thank you, Ms. Greengrass. Would you be happy for Ms. Barrett to ask some questions now, Ms. Barrett?
Sure.
Thank you very much. Good afternoon.
Good afternoon,
I
sir.
just want to deal with a couple of issues about accessibility, first of all. You did actually, in the course of what you were telling the inspector, say that you would prefer to go to Glossop railway station rather than Dinting.
Not by choice, by necessity.
Yeah. But even by necessity, that's about 1.5 kilometres from the site access, isn't it?
It is.
Yeah. It's fully lit and reasonably flat for Glossop, isn't it?
It is, but my concern is the safety when I leave Simonley Lane and enter FP50, which at that point is dark, it's unlit, it's potholed, and it's lined with trees where, in my mind, and I'm sure I'm not alone in this, somebody could jump out on me.
Oh, and let's consider then, if my client's proposal is allowed, there would be an alternative access that would be lit.
But it's just, as I was saying in my statement, I even question walking up towards Morgan's, which is the newsagent that's on Glossop Road in Gamesley, due to the fact that the road, even though it is lit, is tree-lined. There's no properties along there at the first point of it, so I feel very much in a vulnerable situation, as I would do walking up the entrance into the site.
At the moment, the pedestrian cycle routes to where you live are not lit at all, are they?
No. And I have also taken a taxi back from Glossop Station just to feel safe.
That may be right. But what there would be is a pedestrian route that would be lit and a new access. One would expect vehicles to be moving up and down the access.
Well, there was an average of 1 every 2 minutes, but that doesn't doesn't give me an average at 9 o'clock in the evening, 10 o'clock in the evening, when there won't be one vehicle
What you
every 2
will
minutes.
have is a lit route, which you currently don't have.
And the walk up to Morgan's is also a lit route, but I feel vulnerable on that route because it is in the dark. There are dark areas of woodland, which there will also be on the access.
On any view, being fair, that's a benefit, isn't it? You would now have a lit route where you don't have one currently.
It is a benefit, but it still isn't ideal because I still feel vulnerable when I have to walk on a uninhabited route that is dark to the sides of the route. And to the sides of the route, there will still be trees.
And the route that you would be then using would be maintained.
So
You would not expect to find, as you've explained on a couple of occasions in your evidence, potholes.
no, that's correct.
Right. So you would have a
possibly could do if it's not adopted and the management plan doesn't happen because you don't have enough money to support that.
It's not beyond the wit of people, and these days it's not infrequent that you have management companies paid for by the new residents.
Have you walked through Glossop? Have you seen the amount of potholes
I know Glossop
there
quite
are?
well, but I'm not giving evidence, you are.
No.
So the advantage that you will recognise, I hope, being fair to my client's proposal, is that there would be a new alternative access available to the residents that would be lit and much better maintained than the current pedestrian and cycle accesses that are currently available.
With due respect, sir, you are speculating on my feelings and how I would feel walking up a lit
I'm not. It's not you.
footpath.
It's for anybody current resident at Adderley Place. Any current resident would have the benefit of a new access that's well lit and maintained
Correct.
as an alternative to what's there at the moment.
But what I'm suggesting, and have done multiple times now, which you don't seem to be hearing, is that the area to the side of the footpath will still be tree-lined. It will still be dark in those areas. There are places all over the place where there are footpaths which are lit, but they have areas where you feel that there are opportunities for people to hide, where you don't feel safe, especially when you're walking alone at night. You feel vulnerable. I know this might be difficult to comprehend if you're not female. You do feel vulnerable. I feel vulnerable sometimes walking from Glossop town centre back to where I live, even though it is lit. I don't think it being lit and a new access
a judgment.
is a guarantee that my feelings are going to change.
No, I think I've got that point, and I understand it's on the basis of personal feelings, and I do understand the questions that were being asked as well. But I presume we're going to move on to.
I'm going to move on to, of all things, bumblebees.
Yes.
There is reference to the studies that when I say we, it's Wayne Holmes have done and their experts have done it in respect of the bumblebee, and there are mitigation measures for the preservation of the habitats for the bumblebee on this site. Were you aware of that?
I was aware of it, and I think if you listen to the statement that I made, it's very difficult. I can't see a way that you can, find the bees to move them. Indeed, in Libby's, from the Derbyshire Wildlife Trust, last letter, she says that they didn't find them on their more recent survey. But then because she didn't survey every square centimetre of the field, it's difficult to say whether that bee was there or not. I don't see how. It's really difficult. As a beekeeper myself, it's really difficult to even control the bees that you have. You have no control of them. They're a wild animal or a wild invertebrate. So for you to be able to take a bumblebee from one site and move it to another site and then expect it to thrive there or even stay there is incomprehensible.
It isn't a proposal to translocate bumblebees, though, is it?
That's what you were just alluding to, was it not?
No, it wasn't.
How are you going to mitigate?
For translocation.
So are you going to mitigate them with payments?
No.
I've just got to say, can't
No,
you
sorry,
can't
yes, no.
ask the question. You're being asked the
No,
question.
sure.
So
Thank you.
you can qualify your answer and say you're unsure how it would be achieved, but I can't expect Mr. Barrett to answer some of the questions about technical aspects that where he's
Sure.
going to call a witness to deal with those matters.
Okay.
There's
Okay.
an ecology witness calling tomorrow, but being called tomorrow. But in the statement of case, for the inspector's note, there is a proposed wildflower meadow, and part of the proposal will be to maintain a mixture of the habitat on the site that would be suitable and appropriate for the bumblebee. We have understood that there's an issue about it, and we have understood, therefore, and designed a mitigation package so that the environment for the bumblebee will be preserved and maintained, and indeed, it'll be our case, that's going to be enhanced. At
Okay.
the moment, there's no control. What this appeal proposal would bring is a control over those elements of the environment that would allow the bumblebee to thrive.
And have you told the bumblebees that they need to move?
Sorry, is there a question, Mr. Barrett?
Yes,
So
but-
to direct the answer
Are
because
you
it's
aware
prompted
that
a
was the
question back.
proposal?
Yeah.
We haven't discussed with the bumblebee, you won't be surprised to hear.
No,
You weren't aware of the proposal, were you?
I was
Being
aware of
frank.
I was aware of the proposal. I have read the proposal, but I couldn't find anywhere in the proposal that actually suggested how you were going to move an invertebrate from one location to another location when it's a flying invertebrate. Which was why I asked the question, have you told the bumblebee that it needs to move? Because there's no way that you'd be able to move it.
I don't think
it's
you-
happy where it is now.
You haven't understood what I'm putting to you.
No,
I'm not putting
really.
you there's any translocation of the bumblebee. What there will be is an enhancement of the environment that would allow the bumblebee to thrive.
But there's no way of ensuring that bumblebee would, where it's happy currently at Adley Place, will go, oh, it's okay, I now need to go to Chinley.
Well,
Mr. Barrett, is that a matter that your ecology witness can pick up and can address some of these matters?
We can, because there is a... Sir, but just for your note,
Yes.
page 19 of the final statement of case on behalf of the appellants deals with the planting mix specifically designed for the bumblebee. Okay. Thank you very much. I've no further questions.
Thank you.
Thank you, Mr. Barrett. I only have one
Okay.
question, just a point of clarification. You made a comment about the access to the primary school, and just in terms of the selection criteria, you said that it would residents of the new development, if they weren't local residents, wouldn't be able to access places at the primary school. Just so that I can understand, are there specific selection criteria for the local primary school?
It's already oversubscribed. I think Mrs. Darroch will be able to fill you in. She's a mother of 2 children.
Okay. And during my familiarisation visit, I did notice some other local primary schools. There was one a little bit up Simonley Lane, and there are other local primary schools. Are they also oversubscribed everywhere?
I think Taya will be able to answer that.
I can take the evidence elsewhere, but just trying to understand that, because I have familiarised myself with the local area, and I have encountered other primary schools other than the one that has been subject to discussion. So it's helpful to me to kind of understand that kind of interaction with the new development.
Okay, great.
Thank you. I've no further questions though, so I thank you very much for your evidence.
Fantastic.
And Yes, and thank you, Mr. Barrett. And I'm sure some of the issues may be picked up that were raised by witnesses further on. I know you did raise some questions regarding highway evidence, but it may be covered by planning witness. Some of those matters and viability witness in terms of some of the costs and etc.
I think Mr. Hurrigan will be able to deal with it, and in terms of biodiversity, the witness that we'll be calling tomorrow.
Thank you. I'll just await. I'll await some of those responses from the witness, because give them an opportunity, because they'll have heard your evidence and give them an opportunity to respond to it.
Okay.
Thank you.
Just one more point. It's more of a housekeeping note. I know a lot of people have mentioned about the meeting being held here.
Yes.
Is it possible that should something like this happen in the future, that you would consider people giving their comments via online link, so through Zoom or something similar?
We can certainly feed it back in terms of inquiry procedures and how to do things. What I did say yesterday was, obviously there was discussion about the venue yesterday in terms of because of the level of public interest. So 440 plus objections at planning application stage, 800 plus signatures on a petition, approaching 90 representations to the appeal. The council did look for a venue in Glossop of suitable capacity, couldn't identify one.
Sure.
This was provided as the alternative that meet the needs of an inquiry venue. Other alternatives were discussed yesterday in terms of, and they were ones that were considered by the council in terms of using Buxton, but a previous inquiry at Buxton was found to have deficiencies as well. So it's appreciated that there are constraints of venue size for appeals of this nature that have high levels of public interest. What I would say is that inquiries are limited in time. It is that I get the evidence that I need to make my decision. So there isn't a necessity for me to hear the same evidence over and over again from more people. It doesn't add to the strength of the evidence. In effect, if a venue, a hypothetical situation, and this venue was available in Glossop and it enabled a higher attendance of people wanting to speak, because of constraints of time, it's unlikely I'll be able to hear from everyone in any case. And in those circumstances, we do ask for a spokesperson to be nominated. And in effect, that is what the people who were speaking both yesterday and today are acting. I'm taking that as you're representing the wider views and the wider strength of feeling from local residents. So it doesn't the fact that some people may have chosen not to attend. Obviously, we made arrangements via live stream for people to observe, and so people don't necessarily have to travel.
No, it's excellent. I watched it yesterday.
I also amended the starting times. Typically today onwards would have been 9:30, but appreciate people having to travel further than the local area, so starting at 10. So we tried to accommodate attendance as much as possible, but I recognise the strength of feeling, and there isn't, in my view, disadvantage in the fact that more people are offering me the same view. I've already got them in writing, and I will take them into account. So I understand, and I will feed back. And we are, as an organisation, we are looking at technical solutions in terms of allowing people access online. But it wasn't. We did explore it as part of this in terms of, but I don't think it was feasible in terms of setting it up and the ability to do so. It is more difficult for inquiries than other procedures such as local plans, where people have to register to speak because we just don't know who is going to want to speak. So we do have to accommodate for a large venue if there is a large public interest. So I hope that answers your question. Sense. If it doesn't necessarily satisfy you in every
it makes perfect sense. Thank you for answering it.
No problem.
Thanks for the opportunity.
Thank you very much.
Thank you, everybody.
Okay, before we're approaching half past 12. Before I invite the next witness, it may be, given the time involved, we may have to take witnesses after lunch. I'm just asking anyone who's got constraints on time, if who wouldn't be able to be here after lunch, to take anyone now who has that constraint, where we would have to leave at lunch.
There's two of us.
I think I was
Yes, you are due next, yes.
And I could really do with speaking before lunch so that I can go.
Yes.
But
I've got a meeting at 2:00.
Right, that's fine. Well,
I don't intend to be long.
I believe yours was a statement anyway, so the questions may be more limited than.
probably make some.
Yes, no, that's fine.
It isn't very long.
Yes. Well, I'll take your evidence now, and if possible, and if we're close to breaking at 1, and we may extend slightly as long as that's agreeable with the parties just after 1. We'll still try and have an hour for lunch. In those circumstances, but we may go a little bit beyond 1, so we can take those 2 witnesses. Are you okay going in straight after lunch, Mr. Miskell, doing your statement?
I'm fine this afternoon. I'm fine.
That's fine. I'm just checking because I'm just checking the witness list because there's 3 remaining, and so it's because of those time constraints that I'll take you last, if that's okay. Thank you. Okay, can Miss Darroch? Is it Darroch?
Yeah.
Whenever you're ready, the format of questions will be very similar.
Yep.
It's entirely up to you whether you want to read your statement first and then add anything to it. If you just let me know which way you want to do it.
Yeah, I'm just a brief introduction. I'll read the statement, and then if I feel like I want to add my comments at the end, I'll do them at the end if that's okay.
Okay, just let me know when you're
When I'm
moving into the statement, because
Yeah.
those may be the aspects where it may be more difficult to answer questions.
Yep.
Okay.
Okay, good afternoon. My name is Taya Darroch. I'm going to read a statement on behalf of my husband, Ross Darroch, who is at work. Had an evening session been made available or this been held locally, could have spoken for himself and taken questions. We are both residents of Simonley and we have lived in Glossop for 18 years. Okay, so I'll read his statement now. Okay. So, as a resident and father of 2 children who attend a local school, I'd first like to raise my objection at the conduct of this process. The obstacles placed in the path of the residents to make representations, both in terms of location, information about proceedings, and the availability of reports and evidence, is nothing short of disgraceful. The failure of the council to uphold their responsibility to residents by withdrawing strong objections based on evidence at such short notice has left residents without any effective means to contest this development. I will concentrate on what I see as 3 critical areas. Air quality. It is indisputable that the siting of a development of this size, with a single exit adjacent to a school, will increase the volume of cars and consequently congestion outside of the school. There will therefore be an increase in vehicle emission, pollution, and a deterioration in the air quality. This will be exacerbated by the removal of trees in the local area. The schemes alluded to by the developer to mitigate this by contributing towards air quality improvement are blatantly, pardon the pun, a smokescreen. The only viable alternative to cars for commutes outside of Glossop, given the location and paucity of bus services, is by train. I'm quite sure none of the developer's schemes include significant railway investment. The A55 does not have capacity for physical infrastructure such as cycle lanes, nor do other routes out of Glossop. Therefore, let's be honest, no measure proposed will have a discernible impact on the level of pollution at the school site. The removal of this objection by the council is nothing short of an abdication of responsibility for its citizens, and I would be extremely interested to see the justification for this decision. The motivation for this project is clearly profit over people, plain and simple. Money talks, and it would seem to me that the threat of potentially costly legal action has intimidated the council into a withdrawal of their objections. Services. 3 local schools to the development, Dinting School, Simonley School and Charlesworth School, are at capacity. This has been confirmed in the past week by the schools themselves. Glossopdale, the largest secondary, has had to commission an extension and yet will still be oversubscribed. as will St Philip Howard, the only local alternative. Children are currently going outside the area to receive a secondary education. The size of Glossopdale was based on census information and population forecasts, which proved to be entirely inadequate and significantly underestimated demand. It would appear that this development has done similar when asserting there are adequate school places in the area for the families of the development. Similarly, dentists, doctors, amongst other services, are stretched with a lack of availability and long wait for appointments. Whilst this is a national issue, exasperating the problem locally with further development is clearly not in the interests of local residents. Congestion. Congestion on the A57 through Dinting and up Mottram Moor to the M67 is notorious. A survey in 2010 found the junction of the A57 and the M67 to be the most congested in Manchester, and the route has been subject of lobbying since 1971. Such is the blight caused by the congestion. A significant portion of that traffic runs along Dinting Vale, past the proposed development, and is frequently gridlocked outside the school gates. Any contention that congestion isn't an issue and that the road network can easily accommodate the extra vehicles produced by this development is simply not credible. As a local resident, I am all too aware that a trip from home to Tesco to do a grocery shop, a journey of 2 miles, can easily take 45 minutes in standard traffic. Any roadworks on either of the two routes out of Glossop towards Manchester bring the town to a virtual standstill. The road network is demonstrably over capacity already, and any proposal that would add more traffic is irresponsible in the extreme. The construction work itself will cause immense disruption, and once complete, the additional vehicles will cause further misery for already long-suffering residents. Nature. Whilst clearly not a priority of those charged with planning decisions, I wish to finally mention nature. I understand that the developer's proposal, accepted by the council, is to reserve land and plant some trees in Chinley. Well, I'm sure that will be a great consolation to the local residents, knowing they can enjoy some green space a 10-mile drive away rather than on their doorstep. Glossop is losing green space at an alarming rate, with well-documented implications for mental health, which will put further strain on already stretched local services and serve to rob Glossop of its character and heritage. Once again, the motivation for this decision very clearly has nothing to do with the quality of life for the residents and is entirely due to greed. I have read that the purpose of this inquiry is to ensure a better quality of living for everyone now and for future generations. In light of the objections raised, rejecting this appeal is the only decision consistent with that purpose. That concludes the statement.
Thank you.
Okay. So whilst I can't answer questions, obviously, on the statement, I'd like to take the opportunity, if I may, to kind of bring some insight into how it is living in Glossop in the 18 years that I've lived there. I've led my adult life. I now have a family there. Some points that I would like to raise. Myself and my husband do not have an issue with homes being built if they are first-time buyer affordable housing. We moved to Glossop 18 years ago from Stockport because it had affordable homes. We bought our first home when I was 21. It was 100 grand. It's something we're extremely privileged to have been able to do. As a parent now and thinking of my own children coming to buy houses in Glossop, this is something I don't know will be secure for their future. If these houses were affordable houses, I would have a real hard time taking an opposition to them. As it is, these are not. These are large houses, family homes that are completely unnecessary, and the development does not need to happen. The other thing that I would like to comment on is school places. So my children attend a local school. It's one of the three within the vicinity. So I know you asked this question before, but there's Dinting, there's Simondley, and there's Charlesworth, which are probably going to be in the three areas dotted around the site. The closest,
Just to confirm it, I think it was
Yeah.
it was Dinting and Simonley I've
Yeah.
seen, and but I did see
so
the signs.
I live in
for-
Simonley,
yeah.
and me, like many other parents, have actually taken their children to Charlesworth, even though we live in Simonley, and Simonley would be the closest school. In the 5 years that I've had children at Charlesworth School, the class sizes have risen from 12 to 45. So that school is now reaching a crisis point, and discussions for next year have proposed one teacher for 45 children in the infant site, which will cater to reception year 1 and year 2 children. And my child, who will be going into year 6, is going to be taught in a hall because there is no classroom for them to be taught at. Because of this, and it kind of reaching a crisis point within that school due to the growing numbers that it's taken over the years, many parents have said, this is unacceptable, I want to move. And when they phoned the local schools, there are no current primary places for them to move to. So I'm not quite sure whether the forecasting for these places is if people are going to have children once they're in these homes, but I would say people coming into the area who currently have children of primary school age are going to find it extremely difficult to find them places.
Can I just intervene at that moment? Just
Yeah.
ask, in terms of, are you aware of what the selection criteria is for any of those schools?
There isn't.
Is it location based, or are there obviously sometimes some of them have sibling linkages? Some of them are religious. Some schools are religious, so there are different levels.
They do
of
have
criteria on
4 children
selection.
coming in.
Yeah.
So the criteria for selection is location, obviously, when they're increasing capacity, and if you have a sibling. But the issue that people have is, I know someone who has a child in year 1 and year 3 who's not happy with the setup at Charlesworth and wants to move their child to Simonley. And although they have a favour for siblings, they can't accommodate spaces in year 1 and year 3 to move those children across. So if households are moving with current existing children of primary age, they're going to find it very difficult to move them into schools.
Yeah.
Yeah.
Yes, I get that point. Thank you.
Okay, also just on the infrastructure, so I've lived in Glossop 18 years, I didn't have children at the time, I moved from Stockport, I had an NHS dentist there, myself and my husband have used that NHS dentist for 18 years travelling back to Stockport because we've been unable to get one in Glossop. Fortunately enough, they took on our children as well. But we've just been notified that that is now going private and that we will have to find dentists in Glossop, which is a massive struggle. So that is just something as well. We're not alone in that. I have friends that have moved from Anglesey that have a similar thing where they've kept childhood doctor's dentist as an adult and now they're losing those places. Just a point for using cars. I now live in a 4-bedroom house, 2 adults, 2 children on the Simonley estate. The majority of the parents there, even with their children going to Simonley school, drive their children to school. The majority are 2-car households, and that's because if you are supporting a 4 or 5 bed house property, you are more than likely 2-parent working household. And you are not walking your children to school at 9:15 and walking them home at 3:15. You're dropping them at school at breakfast club in your car so that you can go on and do your job. So just the realities of how those houses are going to operate, I would imagine, is quite similar. Lastly, I would just like to say on my experience that the issues that I'm talking about, I don't believe are being created by the development itself. The traffic, the lack of places, the lack of dentists. Those issues already exist in Glossop and they exist for families now. There's crisis points now. What the building will do is compound those issues. And I would argue that for families who would like to move into a 4 or 5 bedroom home, it's a bleak offer, and I would say be prepared for traffic, be prepared for limited school places, and be prepared for overstretched infrastructure, because that is my current experience, and I believe it will only get worse.
Thank you. Mr. Barrett?
two matters I want to raise with you. I'm going to ask that you be given a copy of the committee report that was presented to the Development Control Committee of the Council. It's CD 3.1.
Could I just also say that as a resident, I've had very little communication, and I almost find it infuriating that I'm being presented with documents during an appeals process where I find it's a little too late, to be honest. But I will look at them.
These documents and this document has been in the public domain since it was produced.
I would
It's a matter of record what the council put on their own website. It's accessible. This is a document not produced by my clients, but it's produced by the council.
Yeah, all I can say is that is true, and the reason why you're being drawn to documents is to assist the inquiry is for me as well to draw that point out. So it isn't to come as a surprise to you.
No.
It's if you're aware of it, and also to make me aware as well.
Yeah, and I do fully respect that. What I would just point out is that it is quite difficult as a resident having very little communication over the plan to build and all the proceedings, that unless somebody brings that to my attention as a resident living out there in Glossop, I don't know that these things exist. And I actually have taken more of an interest in it through finding the Adderley Facebook page, but we've had no real official making awareness of where to look for these things, and that's my point that I was making.
Well, it's one of the points that I want. There are 2 points that I'm going to take you to. First of all, education. Then, secondly, I want to deal with healthcare provision.
Okay.
So, can I ask you to turn to paragraph 720, which has a heading: Planning Obligations. Unfortunately, it's not paginated. For the inspector's note, the PDF page, that's the electronic version, is page 55 of 85.
Thank you.
$720.
720. See the heading, Planning Obligation, and I want you to go to the 3rd paragraph of this section.
Yep.
The proposed development has been assessed with regard to its impact on community services and facilities. And then these words: consultees have responded to state that in terms of education provision, there is sufficient capacity at both primary and secondary schools. Goes on to say, however, further capacity is required to stop contributions to libraries and sustainable travel improvements. So that second sentence, that is what the council was told by consultees, and the consultee in this case would, of course, the most important one would be the Education Authority, which is the county council. So it's the county council's view, isn't it, that in terms of education provision there is sufficient capacity at primary and secondary school level?
That is what it states, but as we have experienced in the past in Glossop, that we've been given assurances and information like that in the past that have deemed to be inaccurate and meant that there wasn't enough child places. And I can only speak from my experience currently, which is up to date from last week, that if you have existing primary school age children, you're going to have real difficulty, especially if you're looking at across 2 different year groups, in getting your children a child's place. And that is a simple phone call to be made to those schools to inquire, as many people have done.
And the next paragraph I want you to look at, please, if you would, earlier on in the document, 7/18/16. 7/18/16.
Yep.
See the heading Health Contribution?
7/18/16.
Yeah.
I've got protection of trees.
Not according to this version. It's page 58 of 85 of the PDF. There may be 2 paragraphs.
Yeah, I think some of the paragraphs are all over the place on the report.
Yes. After paragraph 725, it reverts to 7/18/1.
So it's afterwards rather than before.
Yeah. So
All right, so it's after.
Yeah, if Miss Darrett goes back to where she was at 7:20
Yep.
and then turn forwards in the document, you should eventually see at the bottom of a page affordable housing, and then at the top of the next page 7:18.1. And I think Mr. Barrett wanted you to go to 7:18.16.
That's right.
718.1.
17.18.1 under the heading affordable housing over the page. There's then a heading highway contribution, habitat loss and biodiversity contribution. You have to scroll down about
I've
3
got highways
pages.
contribution, habitat loss,
Yeah.
but then the next heading is trees contribution.
Yeah,
Yeah,
and then
keep going.
Keep going.
Next page.
Keep going.
Keep going.
Next page. Health contribution, yeah.
Yeah, 7.18.60.
Yeah.
Okay. What that says, that's a consultation response from the Derby and Derbyshire NHS Integrated Care Board requesting a financial contribution of £90,000 based on 100 dwellings. Because this is a 92 unit proposal, pro rata, that's 82,800. So and actually there's a reference then, it's proposed to secure 40,000. My clients will be providing the full amount requested from the NHS Integrated Care Board, 82,800. You see that?
Yeah.
Now, one of the anomalies of new development is that it is required to contribute to matters such as health contributions, whereas somebody moving from Anglesey to an existing house will not be required to contribute to health contributions. So one of the advantages of permitting new residential development is the opportunity is there to secure financial contributions that would otherwise not arise. Do you see that?
Yeah.
So that my clients actually are going to be doing precisely what the NHS Integrated Care Board asked them to do.
And what does that look like in real terms for residents? Because if many dentists are private and are not taking on NHS patients, how will people access that money?
It can't be from...
Sorry.
No, it's fine. Thank you. It is in the form of a question, so Mr. Barrett isn't obligated to answer it because he's asking you a question.
Yeah.
But he may feel the need to do so. Alternatively, it is a matter that will be dealt with in a later session anyway.
We, the developer, have got to be guided by what the NHS tell us what they want, because they will have a clearer idea of what is needed. And insofar as what is needed is quantified at £82,800, that's precisely what my client is doing. That's to be welcomed, isn't it?
I think I understand it as money that is going to be given. It is hard to understand as a resident how exactly that is going to be delivered as a benefit to the people that live there. One of my main concerns is the lack of NHS dentist is a national issue, and I would imagine if it was able to be solved by a relatively modest sum of money that we wouldn't be in the national issue that we are, and so it's not something I can comment. It's not showing us how it will be directly used to benefit people, so I cannot comment on that.
Thank you. I have no further questions.
Thank you. And just to clarify, planning obligations, there are legal tests in relation to them. So some of the questions that I may have in terms of it will be how that money will be spent and what it would look like. So those sessions again on planning obligations are currently programmed for next week, and they will be live streamed. So you would, when those questions are asked, or I'm directed to documents that contain the information to provide that clarity, that will be available to view.
Thanks. Sorry, lastly, because I know someone's waiting to speak, but closing statements, will residents be invited to closing statements, or will that be for the...
Closing statements at the minute, we're exploring the options whether closing statements are going to be in person or online. The reason why closing statements are typically undertaken online rather than sitting is because there are no questions from me or members of the public at that point. It's just the counsel of each side wrapping up their case, and they provide it in writing, and tend to go through it word for word. So the closings are generally submitted as an inquiry document, so they will be available to view as well, even if you can't obtain it on there. But there's no at that point. There's no discussion. It's the end of the inquiry for me to take away a summary of the case. And it without wanting to put words in the mouth of counsel, it takes account of what's been heard through the inquiry without introducing new evidence at that point.
Yeah. Okay.
So can I just make it clear that
Mr. Richards.
if you decide to do closing statements virtually, there will be a link for members of the public to click on the inquiry website so that they can see the closing statements. But as I say, it hasn't been decided if we'll do that yet.
No.
And so the first thing we will decide, probably towards the end of this week, will be whether that's likely to happen.
Yes, it depends on the progress that we have this week and whether it's possible to close in person on Tuesday. Alternatively, it isn't a good use of inquiry time or people's time to bring them back to the room for closings where they can be done via an alternative means. So it isn't excluding anyone from the process, because it isn't a process that anyone can really engage with.
Yeah.
Thank you.
Yeah, understood. Thank you for your time. Thanks.
Right, we are closing at 1 o'clock, but I'm conscious of the time constraints from Councillor Hopkinson. So I will call you now, just so that. Yeah, well, there's no pressure on that, but we will extend into lunch and then have an extended lunch. When you're ready, Mr. Hopkinson. Sorry, Councillor Hopkinson.
All right. Yep. For the benefit of everybody here, I'm Councillor Adrian Hopkinson. I did sit on the planning committee. One of the difficulties I had with this issue is we have had a report submitted by Highways. I want to deal with the access. The issue we have is that we are told as councillors we have to accept the evidence given by Derbyshire Highways. Going back to it was June last year, we had a similar application. It was one for the Zion Methodist Church on Simile Lane, which there's access from. There was no visibility display on that at all, and I raised this as a concern because my former employment was 17 years on a roads policing unit investigating serious injury, life-changing injury, collisions, accidents and fatalities. So my interest is road safety. We were told in August that we would get training. One councillor even said to me, don't worry, we've had 20 years of this. All I would like to know is the criteria used and by Highways, which we never find out. Nobody knows what's used. We're just told we've got to accept it, which is unfortunate. I had an email on my council email in August last year saying we would be getting it very soon. 2 months' time, it'll be 12 months. I'm a bit disappointed with this because I've looked at this where this access roads are going to come out many, many times. There's clearly been a land grab by the occupant of number 41, who's built a wall which must be 6 feet high, stone wall, which will affect visibility of traffic emerging from the new access road. Like I say, I accept all the evidence that's been presented, but I just would like the inspector to seriously consider this when you go and pay a visit, because there's also something in the report that says land has been acquired. there's nowhere that I can find that, unless I've missed it, that says which new land has been acquired to make this junction safer. Looking at the distance between that wall and the substation gives me very, very serious concern. It's only an opinion, and I'd like it to be taken into consideration. Also, regarding second point, there's the pollution. When the surveys have been submitted on that area and Dinting Vale, they've been an average over 24-hour period. I would have concerns whether if those emissions, nitrous dioxide emissions, what they would be between 2 o'clock in the afternoon and say 4 o'clock. Last Sunday I came back from Marple Bridge. The shortest way would be up the A57. I was sent on the Google Maps because the traffic queuing there was horrendous Sunday afternoon. There is a problem with the sinking of the traffic lights on the A57 in Glossop, which is causing this issue. All I'm asking, it seems a little bit synchronising.
Sequencing, yeah.
Yeah. Now, many years ago, I put in a report when I was in the on the roads policing unit, asking that there was a new Pelican crossing introduced on the high street, and I asked if it could be. It was 150 metres away from a set of traffic lights with a Pelican crossing on. I asked whether they could be put in sequence to allow traffic to flow when they're both on green. I was told it was to slow traffic down. We wanted to slow it down. Consequently, this leads to speeding further up the main road on the A57 because we've got four sets of lights all the way up the high street. No, there's more than that, there's 6. Sorry, if you take it from the bottom of High Street West. It is an issue. I've had correspondence with the council. I just feel a little bit, when we are approving developments, can we sort the problem? There's no answer to this at the moment. It would alleviate the problem. I'm not saying I'm strongly against the development, but I think we need to put actions in place, and I don't think actions have been put in place, before we can approve this development. So that's it. Just seems a little bit. We'll approve the development, then we'll worry about the problems afterwards. And I would like. It would be better if we addressed them first. That's at my pace.
Thank you very much, Councillor Hopkinson. Are you happy to take questions from Mr. Barrett now, please?
Yeah, no problem.
Good afternoon, Councillor Hopkinson. Yeah. I know from the record of attendance that you were present at the meeting in April this year, 22nd of April, where air pollution, amongst other issues, was discussed, including highway safety. What I want to ask you about is your earlier involvement. Were you a councillor in 2016 and 2022?
No, I've only been elected to the council in May last year, 23.
2023?
Yes.
When you were elected, were you aware that there had been this local plan process where this site had been allocated for development?
When I was elected, I wasn't. I made myself aware afterwards.
Yeah, you subsequently became aware of it?
Yes.
And no doubt, as a councillor on the Development Control Committee, you will know the importance of the development plan.
Yes.
And the principle, therefore, of residential development is established.
Yes. What I would say to that is that that plan was produced in, like you say, 2016.
And ratified, that's my word, not the council's word. The issue of whether the plan was up to date was revisited 2022, 12 months before you were elected. And policy DS4
I wasn't aware of that because I had asked the questions why it was a 2016 plan. I asked several questions about that it needed to be updated, and I was told it is currently being reviewed.
there will be evidence about there was a shortened review process which considered the policies and whether the policies were up to date, but DS4 you recognise, and perhaps now you've looked at the plan, there's a requirement to take access from the A57 itself, isn't there?
Yes.
No. Thank you very much, Councillor. I have no further questions of you.
Okay.
Thank you. Thank you, Councillor
right.
Hopkinson. I don't have any further questions.
Thank you very much for your time.
Thank you. We've just past 1 o'clock. It's 1:04. So if we adjourn now at 1:05 and we resume at 2:05. Okay. Right. The inquiry is adjourned. 2, so it's time to resume the inquiry. Just before I call Mr Miskell to provide a statement, are there any housekeeping matters that have emerged?
Yes. Firstly, we have replied to the appellants over lunchtime that the latest draft of the 106 that they've sent to us is acceptable, and therefore I anticipate that they will be sending it through to Kerr Brown for onward transmission for you.
Okay.
Also over lunchtime, in fact about 30 seconds ago, I emailed the appellants the response to their costs application, and Mr Bruin will be forwarding that to Kerr Brown for onward transmission to you. So
Okay.
I anticipate you will get that before the end of the afternoon.
Okay, so should we reserve ID document 9 to...
Yes, when it comes to that, I don't think that the cost application itself has got any sort of formal status in that it's not a core document.
No, I meant for the draft obligation rather
Oh,
than...
yes, the draft obligation, we could reserve ID 9 for that.
Yes.
Do you want the cost application, its response, to have ID numbers and to be uploaded? I mean, they're not appeal documents.
As far as I'm aware, the cost application isn't in the core documents list.
No, it's not.
It's just a separate document.
Yes,
so
because it's nothing to. It's not to do with the appeal.
It's separate to the appeal. So I'm happy for the cost response to be provided and recorded underneath that cost application on the inquiry website. Provided that's agreeable for council.
Yes, perfect.
Yeah, and then we'll just keep separate the documents that are relevant to the appeal and the documents that are relevant to satellite matters.
Yes, because just to explain for those that don't understand, cost application is a procedural matter rather than forming part of the inquiry, and it doesn't influence the decision that I make. It's a separate decision letter. So as such, those details are made publicly available, but it's effectively a separate process that takes place as the inquiry is about to close. Mr Miskell, yes?
Just for clarification, we're talking about costs being uploaded. It's nothing to do with the actual development.
Correct.
No, correct. It's an application. An application for costs has been made by the appellant against the council, and the opportunity that's been given to date, which the council's referring to, is their response to it, which it's requested in writing in advance, and then there's an opportunity given at the end of the inquiry, which it's programmed in after the closings for any oral updates or additions to those cost applications.
This is one on certificate that's being agreed as we speak. As if the development's been approved. Well, thank you for explaining.
No,
This is over and apart.
No, the planning obligation is separate. That does form part of the inquiry. The agreement that's been reached between the parties, and council may help me because there's only a certain distance I can go in terms of explaining this. It's very much like the conditions approach. The parties are putting a legal agreement together in the event that planning permission is granted that will be subject to discussion during the inquiry. The agreement between the parties is without prejudice to whatever questions I have on it and any decision I may reach, both generally on the appeal and on the planning obligation itself. So the agreement between the parties doesn't mean there's any implication for what decision that I necessarily make. It's the evidence that they're ultimately going to put before me. I'm correct. That summary's correct, Mr. Barrett.
Yes, perhaps I can just explain it. This happens at every planning inquiry. The decision maker, whether it's the Secretary of State or an inspector, without prejudice to whether he ultimately grants or refuses the application, will want to know that in the event that it is approved, and there's no decision made in that sense at all at that point, in the event that it is approved, what do the parties say about the conditions that are necessary and meet the legal tests? And there may be an argument over that issue that the decision maker, the inspector or the Secretary of State will decide upon, and the Section 106 obligation. certain matters have to be dealt with by agreement or what's called a unilateral undertaking. And by that I mean, if the parties can't agree and enter into a formal legal document, my clients can go away and do what's called a unilateral undertaking, which is a deed to promise to do X, Y and Z. Because a condition can't require a party to give money, you can't condition a payment. The only way that that can be achieved is through a legal agreement or a unilateral undertaking. And because you've probably heard just before lunch we were talking about the health authority wanting a contribution in the sum of £86,000 or thereabouts, the only way that that can be achieved is through a Section 106 agreement or a unilateral undertaking. And the starting point is that we try wherever possible to agree the matters so that it can be a bilateral, a two-way Section 106 agreement, and if we can't agree then we have to go away and do a unilateral. That's it.
One point, sorry.
Yeah, no, through me, it's fine.
Are 106 agreements binding?
Yes.
So any of them at some stage during development where you turn around and say, we can't honour this, we're going to have to bring it down or curtail the amount or mitigate the amount in whatever form, because the site is now becoming unviable. So therefore, say a 106 of £80,000 might be requested to be reduced down to 40. They're still honouring the 106 in a sense, but not fully.
No,
sorry, Mr. Barrett, just so I can clarify, just in case it wasn't picked up on the mics. The question that you're asking is whether changes can be made to a section 106, and I think that is definitely a matter for legal clarification.
Legal clarification is a Section 106 can only be changed if the parties agree to that change. So, if, for example, we were proffering an £86,000 contribution towards the national health, and the developer at some points wishes to resile from that and says, I can't afford it, don't want to do it, I'm falling out with the dentists or whatever, the local planning authority can enforce that figure because we have bound ourselves to provide that figure. And it would be only if the council said, well, in the light of whatever circumstances, we're going to change it, but we can't force them to agree to any change to the 106. If they want to enforce the 106 in exactly the same way that if you entered into a contract, you can't unilaterally change that contract, that's where a developer would be. Can't unilaterally change it themselves.
Yeah, just a helpful clarification for understanding, because I understand sometimes when there's talk about agreements, it may be confusing for people who aren't familiar. The agreement is between the party and it's on a legal basis, and it's without prejudice to the decision. The reason why I want to bring you to the table is as much for the mic, so it's picked up, so it's on the live stream. So
it's just a query, because we have heard of instances in the past where developers have agreed to a 106 and then halfway through the bill they've come up with that reason. But now you've explained it as all parties that have to be in agreement. It's not like a case of blackmail.
No, it's a legal agreement. You interchangeably sometimes hear us talk about them as planning obligations, Section 106 agreements, unilateral undertakings. The only difference is, as Mr. Barrett said, the unilateral undertaking, that's where one party, the appellant effectively says they will pay that money, and then it's for myself as decision maker to give that weight in terms of and understand how it will be delivered if it's a unilateral payment or works, etc.
If it's a unilateral obligation, they can't unilaterally decide to change it.
No.
Yeah.
Right.
Yeah.
They would need the permission of the council to whom they had offered the unilateral obligation. They would need the council's permission to change that too. So either way,
yes,
the council has a veto, at least for 5 years.
So it stresses the important why it needs to be discussed irrespective of the outcome of the appeal, because obviously if I were in a position where I were to grant planning permission and that that the agreement is in place or as part of that planning permission, I've got to understand its implications.
Yeah, well,
Yeah.
I just wanted to understand it.
Yeah, no, that's absolutely fine. Just housekeeping, anything further before I call Mr. Miskell up to provide the statement? No. Mr. Miskell, if you can just take a seat there. Can you just confirm, once you're seated, who the statement's on behalf of, please?
Yeah. I've got to say, we're taking phone calls left, right and centre, so this is an ever-increasing list. So if I could bear with me, let's make notes. Is that acceptable?
In what sense?
People asking to put a question through on their behalf.
Within reason, and obviously when you're giving evidence, it can be left as a question to hang in the air. But there may be questions. Those questions may then be answered by the appellant calling their witnesses and addressing them, not immediately, because I can't call on Mr. Barrett to answer everything that you may raise. He's helpfully done.
Yeah.
He's helpfully provided clarification where possible,
Yeah.
but it's the role of witnesses and experts to deal with some of the questions. So yes, you can leave them to hang. Yes, you can ask questions of witnesses when they're actually called, but you may not get an immediate answer if you're doing it as part of your presentation of evidence.
Just before I start, Mr. Barrett has done an excellent job, and I can understand how he delivers his line of questions. And you, your good self, have done an excellent job. But people watching this yesterday online, who were thinking about coming down and talking, found it all a bit intimidating when they were sat at this table. So going forward, and I can appreciate, but the people you're talking about, I'm talking about, is someone's grandmother, someone's grandfather like me, who have never been in this environment before, never experienced a formal environment. Then people are out there. And Mr. Barrett's line of questioning is all fine and dandy if you're an expert. Unfortunately, we've got no experts representing the public on their behalf, so we're having to do it ourselves. And it is intimidating. And you can see it on the videos yesterday. People were getting rattled under questions, and we're not used to it. So I think going forward, there should be a document or some sort of notice which goes out to the general public what to expect, how the questions will be delivered. They may sound intimidating, but some way to mitigate that effect.
There is a procedure guide that's published on .gov.uk that sets out the inquiry procedures, and that's the reason. It's understood. It's understood that it can be an intimidating.
It's no reflection on Mr. Barrett or your good self. It's just that this is the feedback I'm getting.
Yes, I understand and it can be an intimidating.
I find it intimidating.
Prospect for participants in an inquiry, and I don't think that that's exclusive to interested parties. I think sometimes it can be intimidating for witnesses as well.
Yeah.
That's the reason why you're asked whether you wish to answer questions or not, and why we'll take statements without questions. Obviously, for the evidence to be tested, you do have to have questions asked of it, but it is at the discretion of the person that's giving it. So there is no obligation to necessarily answer questions on it, but it's recognised.
Which you've emphasised.
It doesn't carry the same weight. Yeah. So that is the process. So there is no. It's within. It's if you allow questions of your evidence and allow it to be tested for it to carry additional weight because it's tested, then Mr. Barrett's within his remit to ask questions of it in a manner to try and obtain the answers.
Yeah, I fully understand that. Getting from A to B, but as I say, for Joe Buckle, who's never been in this environment, maybe people could look at making the situation more inviting. It has put people off.
Yes, I do understand, and that's the reason why we do take written. The written representations that we receive have equal weight to a written statement that's not tested.
Well, I've just got a request.
A statement that's written.
Sorry for interrupting, but I got a phone call this morning saying I didn't realise I could ask someone to come down and speak on my behalf.
So the procedure guide you referred to was expressly referenced and a link provided to it in the inquiry notification letter.
Yes.
But not everyone received that letter. which is another sore point with objectees. And in addition to that, not everyone is privy to online services. People of my generation and a bit older are not fully conversant with going online, following links. So from that point, postal or posts out to the addresses is imperative.
Thank you, Mr. Miswell. All I'll say is that I do have the representations that have been received from the appeal and the notification and the list of those notified together with the site notice. So I can reflect on that point in terms of whether the notification and the consultation was sufficient. But to date, I haven't had any reason or example drawn to my attention that suggests that the measures don't meet the requirements of
I'm not saying they don't meet the requirements. I'm just thinking it maybe it's something someone could look at in the future to make it more convivial. I don't know if that's the right word, but people are put off. It's too formal. It's just maybe someone could look at. I think it's a valid point. You know, you've got people of a nervous disposition, people who've got mental health issues who might make the effort to come down here, but find it all too daunting and walk out again.
Like I say, I understand it is intimidating, and I understand the point that you're making. But that is the reason why there are alternative ways and means of making your representation.
I know it's a tough ask, but I just thought
I understand. I do understand, and I understand when you're not familiar with presenting evidence in public and having it tested that it can be intimidating. But the process of the inquiry and the appeal of itself has more than just sitting in the inquiry giving evidence to actually provide the evidence before me. It's helpful to me to have evidence tested, but obviously there's always been the question whether you wanted questions.
Yeah, I mean that's the proof of the evidence, and I really buy into that. It's just this issue that it does seem intimidating. If you just ring fence that bit and look at it, how can we get around that and make it more inviting for people to come in and speak on their own behalf?
Yes, I understand the point made, and I don't think it's a point that's never been made before in an inquiry either. And it's something we'll pass back as feedback.
Yeah.
Okay.
Right. Sorry about that.
No problem. Statement.
Just one more. As regards the statements I'm reading out, will you require electronic versions?
Entirely up to you whether you want to provide it as an inquiry document.
Right. Well, I think these people who...
The only thing I'd have to ask is there'd have to be a copy provided to each party. I can't take it just as a singular copy, so it may be the case that whether it can be photocopied or something and provided to one of the parties.
So we could not email it to a contact for it to go out to each party?
Yes.
So could an email address be provided to me?
Yes, they'll provide.
And they will be included as part of the inquiry, as documents as part of the inquiry. Yeah.
Yes. It just has to. The parties have to have the opportunity to see it as well.
Just thought I'd clarify that.
No, that's okay.
This is a statement from, or representation from Mrs. Sarah Bott. She attended a meeting yesterday, but because of time constraints, she had to leave. She can't make it down today, neither her husband, so I'm speaking on their behalf. Sarah Bott is a resident whose home will abut the development, so she's got vested interest. I'll start. I would like to speak about 2 points today. One, Nature Recovery Declaration. High Peak Borough Council document. This document outlines the council's pledge, promises, declaration to work bigger, better, more joined up to help reverse the nature crisis. In fact, it states that we need urgent action. Adley Fields is crammed with biodiversity. It is a green space full of wildlife. It does not need improving. It has a high BNG value. It is a space for local people who can walk there easily from Simonley and the surrounding areas. It has a right be in the right place. So we're talking, obviously, about the Great Garden Bee, whose numbers have declined by 92%, which I suppose emphasises the importance of this site. In the right place. How does this development fit in with this promise? How does it follow the 4 principles? There must be more space given for wildlife, existing wild spaces must be improved, the quality of existing wild places must be improved. She's repeated it, sorry about that. The connectivity between the wild spaces must be increased. This development will create a dramatic change to the landscape and cannot be replicated in Chinley. 2. My son Connor is 31, rents a house in Glossop with his family. He would like to stay here. He has hired here. He has lived here all his life. His extended family are here. He would like his daughter to grow up and go to school here. He cannot afford to buy a house built by Wayne Homes or actually afford to buy in Glossop because of the lack of affordable housing. This development is not being built for people like Connor. They are being built for people outside of Glossop. Houses built in Simonley are being built to make money, not to serve the community. In conclusion, taking into account both of these points, it must be obvious that the developer needs to look for more viable sites, of which there are some in Glossop. Ones which can allow for the affordable housing and ones where we can or do not need to destroy valuable wild spaces where we can support the council with its promise to reverse the nature crisis. Thank you.
Just bear with me 1 minute while. I've made an accurate note just in case.
Got a copy of the declaration notice by the council if you want a copy.
Again, if you want to include that in the correspondence via email to accept it as an inquiry document, that's the best means to do it. If there's not copies to circulate to others in the room. Okay, this is another statement, Mr.
This is another statement.
Thank you.
Like I say, I've had to take notes.
Who's it on behalf?
Right, this one is on behalf of Mr. Christopher Wilson, resident of Adderley Place.
Is Mr. Christopher Wilson had a request to view his property as part of a site visit? The name seems familiar. I had a request as part of the appeal representations to do, as part of the site visit, to do a request to view, and I believe it may be the case that Mr. Wilson's not been able to attend. I will try and clarify it via the case officer whether that still needs to go ahead.
Sorry, he cannot attend because he's currently abroad.
Fine, okay.
So obviously he couldn't change the holiday or cancel the holiday at short notice. It would have been a massive cost to him. But basically, he's had to ring me over the phone. He's stating that he requested to Ben Haywood for a traffic survey to be conducted along the footpath, which takes into account the traffic flows to and from the residences as they stand, i.e. 8 houses at Adderley Place, and also the effects which will happen with the use of the lane from the 8 houses which are proposed for the Zion Development Church, and also data which is required to determine traffic movements. So, we've got traffic moving up and down the lane, which all impacts on the exit onto Simonley Lane. In the meantime, we've got traffic going to and from the development, and no one's assessed the effects of the movements or the trip counts on the lane and what that may have. But then he went on to state, if this is approved, basically we're going to be driving through a building site for the next 2 years, 3 years potentially. And how that would affect us is if a car was damaged because a brick came off a construction vehicle, or a construction vehicle was to hit one of the neighbours' cars. How would we go about that as regards recompense? Because if we claim it off our insurance, it's costing us. We lose our no claims and that. But it's something to look at, because we are effectively going to be driving through a building site for the next 2 or 3 years. There's no 2 ways around it.
Mr. Biscoe, just Into the microphone to me rather than towards Mr. Barrett, please. It's okay. I'm taking your point, but Mr. Barrett can't answer the questions while you're giving evidence.
So, I mean, that's Mr. Wilson's query.
Okay.
Then also, in addition, got a request from Councillor Harding to ask about the air quality at peak times, say 7:30 to 9:30 a.m. and 2:30 to 6:30 in the evening. A mean 24-hour reason is completely false, as traffic through the night is extremely quiet.
Sorry, what were those times?
7:30 till 9:30 a.m.
I'll just clarify. Mr. Hardy did present evidence, and that request's already before me.
All right.
Yeah, that's already before me in terms of.
Well, he emailed me last night to ask the question, so obviously I wasn't privy to that.
Yes, no, he presented evidence, I believe, after lunch yesterday afternoon, and then.
I was there.
Sorry. Yeah, he definitely presented.
We were just saying the same thing.
Yes.
I'll check my notes.
Yes,
that's one of the.
I'll check my notes, but it was definitely Councillor Hardy, and he definitely presented evidence expressing concerns about the monitoring of air quality, that it's an average rather than.
Yeah, I think he's trying to get across the point that if it's a mean average over 10 hours, and there was 1 hour where there was a spike of 50 ng, and you do that over a mean average of 10. Would it read as 5?
Yes, that's effectively the evidence that he's already given.
Right.
Yes, thank you.
Well,
I
actually sat there and, no respect. I just thought it was a question he'd forgot to ask.
No, I've definitely got it in my notes because I've noted it down as something to ask the witness.
Mr. Bennett has sent me through, who unfortunately couldn't make it again today because the location of the venue, and is put, Hi Phil, I see you're at the inquiry today. Would it be worthwhile getting verbal confirmation from the developer, appellant, that no construction vehicles will be allowed to access the site during the construction phase from Simmonley Lane if the appeal is allowed, and as a planning condition also to get details of the disruption to traffic on the A57 during construction and how this will be managed.
Okay. That's a matter to which I'm sure Mr. Barrett can call witnesses later to address that in evidence. So it's likely to be, I'm assuming it'd be the planning witness that
it would be Mr. Hurrigan.
So he's expected to be called next Tuesday because we're waiting for the viability of witnesses' availability, which is next Tuesday, and then the planning witness typically wraps everything up at the end.
I've just got one question or one request, and it's to the good people sat opposite from the council. Again, back to my phone. In 2020, the council made a request to Homes England for funds to progress the site or aid in progressing the site at Adderley Fields. I believe it was, the first tranche of requests for this money pot. The government was provided, and the council at that time was unsuccessful. The following year, in 2021, Homes England dropped Adderley Place from the local authority accelerated construction programme. Now, I've tried to trace what the reasons were behind it. So could the council facilitate myself and this inquiry with the reasons why Adderley Place was removed from Home England's exercise?
Thank you, Mr. Miskin. I've got a note of that, but because the council isn't calling any witnesses, I can't ask them to reply publicly in the inquiry. Because
right. Can I ask that question?
What I can ask you to do is I'm assuming the council will be providing you with an email to provide the inquiry documents. Yes, yes, and it may be a question that you put to the council, and they may wish to answer it or not separately. But I can't ask them to present evidence in the inquiry.
You provided me with an email.
Yes.
Can you just confirm?
It may, if you
gave you a piece of paper with an email address on
Mr.
it.
Miskin.
Right. As regards that question,
Mr. Miskin, if you're providing personal details, it's better to do it outside the inquiry, just with us being live streamed. So I just encourage those discussions with the council to take place outside of the inquiry, and I can't ask questions of them, unfortunately, because there's no witnesses to be called to deal with such matters.
right? In relation to these statements for electronic versions, can you email? Have you got my email address? Just email. You've got it there. Lovely. Excellent. Okay, I'll send that back to the people involved. I think on that note, that's me done.
Thank you very much, Mr. Miskell, and for providing the statements on behalf of others as well. It's very grateful. Thank you.
And thank you for the time and the opportunity, and your good self.
Thank you. Is there anyone else here who wishes to speak before we move on to calling witnesses? Thank you. Mr. Barrett, can you call your
Elizabeth
next
Whitall,
witness?
please,
Thank
sir. So, and whilst Miss Whitall takes her seat, so to speak, proof of evidence, her appendices, and CD 2.35, and there's another one here, should have that as a number, and CD 210. 210.
Yes, so I think I'd already anticipated these documents. So I've got the revised air quality assessment, which is that 210?
That's 210.
And then I've got the travel plan. Is that 236?
Yes.
Yeah.
There is one document, I don't believe we need to go to it, but for members of the public and others, 614 is the council taking the issue of air quality to committee on the 22nd of April this year.
Thank you.
I referred to it earlier in the inquiry.
It's worthwhile having it in front of me.
Yes.
If there's any copies around, if people want to obtain them, if they do want to ask questions, it's worthwhile having that to hand, because it may touch upon questions from members of the public, or it may touch upon questions that I may ask.
Perfect, sir. Ms. Whitall, let me take you to section 2.1 of your evidence. You are a senior environmental consultant in Royal Haskonig, a UK company specialising in environmental renewables and resilience. Is that correct?
That's correct.
The company is an independent international engineering and environmental consultancy. It has 6,000 staff in offices based in 30 countries and about 600 in the United Kingdom. And you've been employed in a consultancy role for nearly 3 years. You specialise in air quality management, emissions impact assessment and atmospheric dispersion modelling, and you provide services to clients in environmental impact assessment, development, consenting, compliance and due diligence. All that correct?
Yes, correct.
You personally have a Bachelor of Science honours degree in biology. You're an associate member of the Institute of Air Quality Management and of the Institution of Environmental Sciences. Is that correct?
Yeah.
Prior to your current role, you were employed as an environmental consultant for 4 years at IDOM, which is an independent international engineering, architecture and environmental consultancy. And again, whilst you were there, you completed air quality impact assessments for a wide range of developments, including large-scale residential, industrial and mixed-use schemes. And your current project work as a senior environmental consultant includes the delivery of several air quality chapters for inclusion in various environmental statements for nationally significant infrastructure projects. The projects entail detailed air pollutant emissions modelling for road transport and regular stakeholder engagement. All that correct?
Yeah.
Section 3 deals with the scope of your evidence, and because there is no longer a difference between the main parties to the appeal, what I want you to address really is how we got to where we are, and then address the concerns that members of the public have articulated in consultation. Try and take a run, skip and a jump through it. After the initial air quality report was submitted, the Council's environmental health officers asked for the effect of the A57 link road to be assessed. And that report then is CD 210, is that correct?
Correct, yeah.
They subsequently requested clarification of the assessment methodology, and that's CD 2.35.
Correct, yes.
We can see, without necessarily going to it, the Environmental Health Officer's consultation response on this application in CD 3.1, that's the officer's report, and they are essentially on pages 29 and 30 of the PDF pages, 29 and 30 of 85, and paragraph 715.2 on page 48 of 85 of the PDF version. Again, we know what the recommendation was. I don't think we need trouble ourselves there. Right. Let's turn, if I may, to some of the local concerns. And you number these on your page 5 by reference to those bullet points, concerns 1 through to 5. Is that correct?
Yes, correct.
And the first concern really is the air quality management area. Most objections raised having concerns regarding the impact of the development on the levels of air pollution in the Dinting Vale AQMA. See that?
Yep.
CD 210, you looked at that issue in the context of the approval of the Mottram bypass, is that correct?
Yep.
First of all, I think we have to look at briefly methodology. Did the study comply with the United Kingdom guidance on the preparation of air quality assessments?
Yes, that is correct, and it was agreed with the pollution specialist officer at High Peak Borough Council.
Yeah, that's clear from your paragraph 4.8, is it not? The matter, that was a matter of agreement.
Yeah.
And you were looking at essentially 3 elements: nitrogen dioxide, small particulate matters, PM10s and PM2.5s. Will you briefly explain what, maybe self-obvious, but what particulate matter is and why it's important to look at it?
It's essentially dust in the air. We specifically look at particulate matter with a diameter of less than 10 micrometres and less than 2.5 micrometres, as they are the fractions of dust which are considered to have a cause for concern on human health.
Sorry, can I just those figures again, please, just so that I can note them down?
Yeah, so PM10 stands for particulate matter with a diameter of less than 10 micrometres. And PM2.5 stands for particulate matter with a diameter of less than 2.5 micrometres.
Thank you.
And why is it relevant to look at those matters as a touchstone for health and well-being concerns?
They are the pollutants generated from exhaust emissions which are concerned to potentially result in health-based issues.
Right. 410 then, the assessment demonstrated that predicted annual mean concentrations of nitrogen dioxide, PM10 and PM2.5 would be below the United Kingdom government's prescribed objectives, both in the existing baseline and with the development completed in 2026. I'm going to unstitch some of those elements because members of the public are concerned to understand why are you looking at the prescribed objectives in circumstances where the members of the public are saying, well, you should actually be looking for the peak hour of pollutants. Do you follow?
Yes, so we are required to assess against the UK government's air quality objectives. They have for nitrogen dioxide an annual and an hourly objective. For PM it's an annual and a 24-hour objective, and for PM 2.5 it's an annual objective.
Sorry, can just run me through those
Yes.
again a little bit slower. So start off with the first one, the UK government objective.
So for nitrogen dioxide, it's an annual objective of 40 micrograms per metre cubed.
Thank you.
And an hourly objective of 200 micrograms per metre cubed, not to be exceeded more than 18 times a year.
Okay.
For PM10, again, it's an annual objective of 40 micrograms per metre cubed. And a 24-hour objective of 50 micrograms per metre cubed, not to be exceeded more than 35 times a year. And for PM 2.5, it's an annual objective of 20 micrograms per metre cubed.
Okay.
Thank you.
Just before we take the step forward and ask the questions whether that was complied with, the levels that have been set, are they to protect human health?
That's correct, yes.
And would that include people who are young, old, and or with respiratory challenges?
That's correct, yes.
Is that standard consistent across Europe, or is that bespoke to the United Kingdom?
Each government has their own objectives.
And where do ours stand in terms of the assessment by the UK of what is required?
In line with the EU objectives.
What is the outturn of the assessment you did against the standards, the prescribed objectives?
The assessment demonstrated that air quality in the opening year of the development would be below the UK objectives at all assessed locations of public exposure, and the impact of the scheme would be negligible in line with best practice guidance.
Okay. Your assessment, I can see from paragraph 412, was based upon 111 residential plots.
That's correct, yes.
We know that this development seeking full planning permission for 92, so it's not going to be 111. What's the implication of that?
The air quality assessment is therefore a worst case assessment, and the development would actually result in fewer trips and therefore a lower increase in pollution.
Can I ask you to go to your table 1, PDF page 10? It's page 9 of the hard copy if people are looking at the hard copy. And you have, on this table, the identification of the diffusion tube, where it's located, type of site, and then you have figures for 2017 through to 2022. If I look at Dinting School, which is HB 21, and we know a lot of people have expressed concern about the school, we see in 2017 that the levels, because you've emboldened them means that they're in exceedance of the prescribed objective. Is that correct?
Yes, correct.
And that gives rise to the declaration of an AQMA, doesn't it?
Yeah, correct.
They were still in exceedance in 2018. 2019, they have come down and are just below the level prescribed objective. In 2020, we all know what was happening in 2020, the pandemic. They are significantly below 29.3. it has risen slightly in 2021 and fallen back slightly in 2022. Can you just perhaps anecdotally say what was happening in those years that will demonstrate that those are pretty robust and explicable changes?
So in 2020 and 2021, as we highlight in the proof of evidence and in the air quality assessment, there was impacts of COVID-19 on traffic levels, so we do have to take those years with caution. But in 2019, traffic levels were unaffected by the pandemic, and it is assumed in 2022 that it's the same again. Traffic has returned to peak pre-pandemic levels, so we can clearly see that there is a decline in air pollution within, well, at Dinting School, but also throughout Dinting Vale.
Now, the highest in 2022 across the whole of the diffusion tubes was 37.6. On that basis, there was no exceedance at any of the measuring points of the prescribed limits. Is that correct?
That's correct.
Even that one, is it representative of residential and public exposure? HPE 25 it is.
No, HPE 25 is a curbside site, which means it's located within 1 metre of the road. It's also located on a lamppost at the junction with Glossop Road and the A57, so it is not representative of public exposure because it is located closer to the road than residential property, for instance.
Can I ask you to scroll forward then to table 2, which is on page 11 of the PDF, so page 10 of the hard copy. You reference in 419 DEFRA background mapping data. Can you tell us what this is intended to show? We can see its annual mean concentrations, microgram per cubic metre. What's the table showing us?
So DEFRA, which is a government department, produces data on the forecast of air pollution into the future. And this table is demonstrating that background levels of air pollutants are predicted to decline into the future. So compared to a base year of 2018, the 2026 levels are lower. And that is the opening year of the development.
I was about to ask you that. 2026 is the anticipated date when all 92 dwellings will be occupied and people will be using their vehicles. So what implications would that have for the AQM? Would it still need to be in place because there was a lack of success in achieving the objectives?
I can't necessarily comment on whether the council would take away the air quality management area, but if we focus on the data, it's clearly showing that there is a decline in pollution since it was declared in 2019, and the forecast is that it will continue to decline into the future, and obviously the monitoring data supports that. So all the evidence suggests that concentrations will be lower than those currently experienced in 2022 at the opening year.
At paragraph 422 on your evidence, page 12, 11 of the hard copy, the second concern members of the public are expressing is the pollutant concentrations at the primary school. They're concerned particularly because of the children being present. Can you just, if I draw your attention to the end of 422, in the opening year of the development, 2026, annual mean concentrations of nitrogen dioxide at the primary school will be further reduced below 75% of the air quality objective.
Yeah, that's correct. So in the existing levels, well, in 2022, the existing levels of air pollution were below 75% of the air quality objective. Therefore, we can confidently say in the opening year, it's likely to be less than 75% of the air quality objective at Dinting Vale Primary School.
And to an extent, we can see that in table 1.
Yeah.
HP21, the diffusion tube there is at the school, and
yeah,
it shows the decline from 2017 to 2022.
Yeah, the diffusion tube is also located on the facade of the school closest to the road, so it is representing a worst case exposure.
and you say in 423, the assessment demonstrates that the proposed development will not result in levels of air pollution in exceedance of the UK government's human health-based benchmarks at the school.
Correct.
Okay. Concern 3 then, traffic emissions from increased congestion. You explain in 425 the detailed model that's used, which is essentially provided by highway consultants who are able to assess the number of vehicles that are likely to be on the A57 and then the contribution that the development would make to that and make judgments about the capacity of junctions that would cause traffic to back up. I'm summarising a lot of Mr. Roberts' work in a couple of sentences.
Not quite. So we obtain the traffic data from their traffic models. However, we input it into an atmospheric dispersion modelling software. And these are the parameters that have been used in that dispersion model to calculate air pollutants.
And as a result of that, you tell us at 426 it's a robust assessment as it deals with the effect on exhaust emissions both from idling vehicles and peak traffic movements, as well as increased traffic flows from other committed developments.
Correct, yes.
Okay. And that's able to take into account the model used, reduce vehicle speeds, you tell us, time, varying emissions, filed to take account of the variation of traffic hour by hour, and day by day in various weeks, work days, and peak hours and the like, an increase in traffic on the roads in the opening year as a result of traffic growth from committed developments.
Yeah.
So you take into account development that's going to occur that hasn't occurred yet.
Yes, correct.
Okay. I think we then turn to 4. I think that's a concern relating to the air quality monitoring data relied upon for the assessment. At the time, you tell us in 427, when the first assessment went in, the 22 data wasn't available.
Correct.
That was then updated subsequently when that data did become available. Is that right?
Yeah, the 2022 data in the proof of evidence was released after we completed our air quality assessment.
And because at the time it was being prepared, COVID would have had an impact, you used the base year of 2019 being the year that was not affected by COVID.
Yeah, correct. And
you explained that at 428, do you not?
Yeah, and that was agreed with the pollution specialist officer at High Peak Borough Council.
You then explained 429, model verification. Would you just briefly explain, if you would be so kind, what model verification is and what it's intended to achieve?
Yes, so it essentially ensures that the model is accurately predicting concentrations in the local area. So we input the model parameters, so that's traffic data, traffic speeds, meteorological data into the model. We then generate the output and then compare that against monitored data in the local area to ensure that the model is accurately predicting. So in this case we use 2019 data and then adjust the output in accordance with that.
I'll try and put it in my own words, tell me if I'm wrong. The computer model output then is correlated to actual real life data to make sure that the model's working properly.
Correct, yes.
There is a reference in your 430, we'll deal with this, it's a relatively isolated point, but it may be regarded as important. Why wasn't there any site-specific monitoring of air quality at the development site itself?
So High Peak Borough Council undertakes monitoring throughout Dinting Vale, as is presented in Table 1 of the proof of evidence, and also included in the air quality assessment, and this data can be relied upon for the air quality assessment.
Okay. Turning then to mitigation measures, there's some discussion here. First of all, the main points would be implementation of a travel plan that incorporates measures such as electrical vehicle charging. So the houses will be provided with electrical vehicle charging.
Yep.
So if people elect to use an electrical vehicle, electric car, they can do so. and cycling provision.
Yep.
The travel plan itself also has measures to encourage car sharing, the usual travel plan exhortations. Would that assist?
Yes, that would also.
And then there's a Section 106 contribution of £150 per residential dwelling. Would you just explain what that is? What is it for, perhaps more accurately?
So it's a contribution by the applicant to be used by the council as they see appropriate to help improve air quality in the local area.
And what can that be used for? To help direct monitoring, real-time monitoring, I think was one of the issues.
That was a suggestion by the council, correct, that they could install a real-time monitor.
And if any surplus, then that could be deployed to help them bring forward other measures in the action plan, the Air Quality Management Area Action Plan.
The Air Quality Action Plan, yes, they could use it as they see appropriate to enforce the actions within that.
Okay. I just need to focus on this point. Obviously, the case that was made on behalf of the appellant and the air quality assessment that was done, was that tested by the environmental health officers of the council, and all the assumptions that were behind it and challenges were made throughout the course of that consideration?
Yes, correct.
And we know, obviously, because you can see it in the officer's report, CD 3.1, how the environmental health department, how the environmental health officers dealt with then and made their recommendation based upon their own assessment of your work. Would that be a fair summary of what happened?
Yes, it would be.
Don't think I've got anything else in terms of air quality. I'm just trying to pick up whether there's anything that the public have raised that we haven't covered. I don't think so, because I think the main point, you remember Councillor Hardy was concerned to look at why are we using an average when there will be peaks and troughs in activity? Why is that done? Perhaps I can ask that question. Why do you use the methodology that's prescribed for you?
Because we are required to assess against the UK government's air quality objectives, and as mentioned previously, that's an annual average and an hourly average. For this instance, High Peak Borough Council declared Dinting Vale Air Quality Management Area for annual mean exceedances of NO2. Therefore, it can be ascertained that their concern is exceedance of the annual mean objective and not the hourly mean objective. However, nevertheless, we have assessed that in our assessment and concluded that the short-term or the hourly mean objective would not be exceeded.
Thank you very much. Thank you, sir. Thank you.
Are there any questions from those who wish to speak? Mr. Miskell? Through me, and then I'll relay the question, please.
I think during the time of the testing, St. Patrick's was subject to subsidence towards Sheffield. The A57 is the only and primary route going in that direction. And it's closed for some months, and since then it's been subject to restriction as regards heavy vehicles. Did you factor that into your plan?
I'll relay. I'll relate for the microphone, and then yeah. So the question is, if those at home observing couldn't hear, it's Snake Pass East, which the A57 leads to past Dinting Vale, has been subject to subsidence and therefore restrictions, including closures for significant periods of time. I think you referred to months, didn't you?
Months.
Yes, months. And the question was whether that's factored in to taken account of as part of the assessments.
So, my knowledge of the subsidence isn't that great, but I understand that it's happened since 2019. For the purpose of our air quality, or the air quality assessment done on behalf of Wayne Homes, the assessment uses data from 2019 to inform the impact of the assessment in the opening year of 2026. So data from 2020 onwards is useful to get an idea of what conditions are moving into the future and beyond, but it doesn't actually impact on the results of the air quality assessment.
Through me, please.
Well, surely, if there's less traffic moving in an eastward direction, and there must be a correlation between traffic movements and pollutant levels. If you've got less traffic moving in a certain direction, surely you would expect the level of pollution to drop accordingly. So if 10 cars cost, say, 50, 5 cars would cost 2.5, so your level comes down. You understand the drift? Sorry, I'm not up on the technicalities of it.
Thank you, Mr. Miscott. Yes, basically talking about car numbers. It's whether it's a query about the reduction in numbers of vehicles travelling towards Snake Pass East during the restrictions. Whether, obviously, if that's factored in some form in the methodology. And I know you've just given an answer that says that you were using 2019 data, which was prior to it. So I don't know whether, to what extent you want to, you can qualify or add to your previous answer.
So traffic levels do impact air pollution, that is correct. However, in this instance, the closures of the road which may have impacted on traffic in recent years, as far as I am aware, weren't impacting in 2019. And as I mentioned, that's the year of data that we use to inform our assessment and verify the models against. To obtain a future year concentration, we use DEFRA's tools, which creates forecasts on emissions in future years. And the future year assessment is informed by traffic data provided by the traffic consultants.
Thank you.
Yeah. Well, in addition to that, traffic going east was restricted. There's also major restrictions on the traffic going in a westerly direction, because the A57 was subject to major use-of-lane works over a 20-week period. So obviously drivers used every other route. So obviously the levels come down. I'm interested how this works. So you refer to, as a baseline, you use figures in 2019. Yeah, they were quite high. So obviously we're starting from a peak up here, and subsequent years are showing a downward turn. Surely you should have started down there and just to see what the rise was. I find that confusing.
Yeah, I'll relay the question for the microphone. So the question is, it's about the 2019 baseline, how it's been used to show a downward trend, and why, what may have influenced that peak to go downwards as opposed to a forecast going upwards. Is that a summary?
Right, we've got a problem with air pollution. So let's start at zero as a baseline and see if it increases or decreases over the next 4 or 5 years. So if you've got a problem, you would expect that to increase. To turn it on its head and start with the highest level of pollution levels recorded in 2019, surely all you're going to read is a drop-off. You grasp what I'm saying?
I can relay that. So we talked about how longer term trends and the monitoring position that's taken in terms of forward forecasting, how that may influence it, and whether the fact that it's taken a large figure has any bearing on what the outcomes might be thereafter.
So in accordance with the best practice guidance, air quality models are required to do the process of model verification. So for that we have to take a base year concentration. Typically you would want to take the year of which you were undertaking, or the most recent year of which you were undertaking the assessment. But because of COVID, we've had to use a 2019 base year for that. The presence of high concentrations in 2019 actually make it more of a robust assessment because you're verifying the model against high concentrations, and therefore you generate a larger adjustment factor. So you are increasing the impact of the scheme by a larger proportion than if you were to verify it against lower monitoring data. So by actually using a high concentration in the base year, you are creating a robust and worst case assessment. And then as for the decline into the future, the forecasts show that there will, or forecasts are that there will be a decline into the future based on the government's research, which is verified. So using the tools provided by DEFRA, the model, regardless of a starting position, shows a decline into the future.
What are the drivers of the government uses indicators to say these levels will drop?
So sorry,
I'll relay the question. So just for the microphones, so it's what has the government used as indicators that's driving that trend?
So it's the uptake in electric vehicles. There are no release of NOx or PM from exhaust emissions in electric vehicles. There are reduced emissions in hybrid vehicles. It's also the introduction of higher Euro standard vehicles for both heavy goods vehicles and low goods vehicles. That is a driving force for the reduction in pollution into future years.
Right. So I do have a problem with that because, yeah, in an ideal world, the government was trying to get everyone to promote everyone to go electric. I'd love to. But what we're finding is, because of the cost of those vehicles, people are now going back to diesel or petrol. So the government has realised this figure of after 2030 cannot more than be produced. That's been pushed out, so obviously that must affect, I think, figures, or bring them into suspect. As regards the A57, I can buy into that, whereas nitrous oxide levels will drop if more people do take up electric vehicles. But also as well, as there's less traffic going through that area, because of the restrictions on the state paths, it will drop anyway. But in addition to that, if I'm correct, the diffusers only pick up NO2 levels and PM10. Am I correct?
Okay, so it was a long question and commentary. No. I'm just breaking it down. It was a summary. It wasn't a criticism. Just it was a long question about trends in terms of the EV take up and the pushback of sale of petrol and diesel cut off effectively, and how that affects it. That recognise that there will be some drop off from EVs, but then asked a specific question about diffusers, that whether they just pick up NO2 and certain particulate matters.
So as for the uptake of vehicles and the future decline of emissions from the monitoring data within Dinting Vale, it's evident that there is a decline in pollutant emissions.
Due to the uptake in electric vehicles, that's been evidenced.
From the monitoring data.
I think it's broadly part of the same question in terms of electric vehicles.
So can't attribute it, however, it's strong evidence to support that. So the monitoring data that is contained within Table 1, the diffusion tubes are all roadside and curbside sites, so they're all placed specifically to obtain measurements from road emissions.
Nitrous dioxide and PM10, that's it.
So, sorry, I'm still answering the first part.
Yes, it's just qualification. I'd just ask you, Mr. Miskell, just don't interrupt, because I think the answer was ongoing. So if there is a specific follow up, okay.
So that's fine. So, sorry, lost my train of thought then. But
it was about the diffusers and the NO2 and the particulates, I think.
So there is no monitoring of PM particulate matter in Dinting Vale. There is monitoring only of NO2, because that is the pollutant of concern for High Peak Borough Council in this area.
So
Through me, please, Mr. Miskell.
So, in effect, all we're monitoring is one type of pollutant. Even with the take-up of electric vehicles, particulates less than PM10 are not being recorded. And from electric vehicles, we will get brake dust, tyre dust, general wear and tear on the vehicle, from an electric vehicle, from petrol, diesel, we've got carbon monoxide, various other onerous gases which are being emitted. So we're just looking and focusing on one type of pollutant, yet we don't have any idea of what levels we've got as regards PM10. So we've got young children being subject to tire, and tire dust is a killer. It's a proven fact. I think you'll agree with me on that. And carbon monoxide is emitted by vehicles. And we're not recording it. That's not your problem. I think that's a problem with the council and the environmental. We're focusing, and I can't for the life of me understand why, on one type of onerous gas when a vehicle produces possibly 10 associated.
Thank you, Mr. Miskell. I'll just I'll summarise it for the camera, and you can confirm its case. General concerns about EV, and particularly that particulates come from tyres, brake dust, etc., and that currently the monitoring from High Peak is focused on NO2 rather than particulates. And putting it in the form of a question, have you any views why that might be?
So just to be clear, the air quality assessment does deal with both NO2 and particulate matter. It's just the focus is NO2 because that is what High Peak Borough Council deemed to be the potential risk in this area in terms of exceedance of the air quality objectives. So the air quality assessment produced on behalf of the development does include assessment of particulate matter, and that's PM10 and PM2.5 and nitrogen dioxide, all of which are shown not to exceed the UK government's air quality objectives. And then in terms of the pollutants of concern, so nitrogen dioxide and particulate matter are the pollutants that are considered to be of a concern from vehicle emissions to human health.
Mr. Miskell,
So the diffusers do in fact pick up PM10s?
No.
Question about diffusers.
So there are two different, there's a diffusion tube which monitors monitoring which is undertaken by High Peak Borough Council, that only monitors NO2. But the detailed modelling that was undertaken as part of the air quality assessment that predicts concentrations of NO2 and PM10 using best practice techniques and best available data, all of which was agreed with the Environmental Health Officer at High Peak Borough Council, and the results of which were agreed by the Environmental Health Officer.
So in effect what I'm saying is, council ones only pick up NO and PM, don't pick up PM10s. Your team went down and put additional monitors in place to pick up the pollutants and PM10s, I would say. Or have you relied solely on data provided by a QMA assessment on a yearly basis by the council from back to 2019? So in effect, you've not actually been out to site and took your own recordings. Just as a measure of confirming that the data you're using for your model is actually correct.
Thank you, Mr. Miskell. Just to reframe, the question is whether any additional monitoring for particulates was undertaken. You may have answered it. I think you may have, but just to reconfirm that, or whether it was a reliance on the modelling. And then to assist me, adding to that, if you could elaborate on why you consider that approach is robust in terms of if you are relying on modelling rather than physical monitoring data.
So no additional monitoring was completed. However, it is widely accepted by local authorities and DEFRA that the available data on PM from emissions rates and the background data provided by DEFRA is suitable to assess the levels of PM which will be generated by a development.
So, is there a this is my question. Is there a correlation between, for modelling purposes, levels of NO2 and particulate generation, or are they independent from each other?
They're independent, so there's a tool called an emission factor toolkit which is produced by DEFRA, and within that you can put the level of traffic that will be on the roads and also increased by a development, the proportion of traffic split into light good vehicles, heavy good vehicles, speeds at which they'll be travelling at, and the tool will then generate the emissions which will be produced by that volume of traffic under the specified conditions. Those emissions rates are then used in the detailed modelling exercise to predict both the total concentrations and the impact of a scheme.
So is that NO2 or is that particulates or both?
Both NO2, PM10 and PM2.5.
Thank you. Anything further, Mr. Miskell, or is that just a point for me to reflect upon? Because we are getting very close to exhausting all lines of inquiry on that point, and I don't think you're ever going to get the answer you necessarily want.
Well, 2 points. So in effect, so the last 3 or 4 years, we've got gaps or potential gaps in the data due to restrictions on A57 going east, going west as regards to 20-week blockade going out. So that has brought traffic levels down. So therefore you would expect, accordingly, because there's a correlation between the two, the nitrous oxide levels to come down. So it will, regardless of the model, it will show a fall. But in addition to that, can you quantify, I mean, I've heard the statement that the levels of pollutants coming off new development will be minimal or negligible. Can you quantify that as a percentage?
Just 1 second. So, just for those who may be observing at home, Mr. Miskell raised that there's gaps in data, A57 traffic movements east and west, which we've already broadly covered, but traffic levels down. Assertion, and which is probably one that I'd make, that NO2 would understandably therefore be down in that monitoring period. And then asking for your view, quantifying that the new development would be minimal or not. Now, in terms of the first example, we've probably gone round a few times on the closure of the A57, and obviously we've heard the answer in terms of the 2019 data. I don't think that answer is going to change. So I'd like to assist the inquiry and to move things forward. I'd just like that final bit, the quantification of whether there's proportion in terms of the new development, whether the reference to it being minimal or negligible, that kind of the component that the development might bring to it.
Yeah, so there's a guidance document which is produced by the Environmental Protection UK and Institute of Air Quality Management, which quantifies a significance criteria based on total concentrations and also the predicted impact of a scheme. So the higher the concentrations are, the more the higher the significance criteria is. So for instance, if you've got a higher total pollutant concentration, taking the highest concentration in Dinting Vale of 37.6, then an impact on that total concentration would therefore see a higher magnitude of impact. So in this circumstance, anything less than 1% change is defined as negligible.
So we're talking about less than 1%?
Less than 1% change, but just to reassure that higher concentrations, the impact is considered more higher significance criteria.
So, am I allowed one more question?
You're allowed one more question as long as it's advancing rather than going round.
No, we're not. So, coming off the development, to ascertain the potential pollutants coming off that times a cow would go in, how many times a cow would come out. Can you just off the top of your head tell me what that trip count was?
Sorry.
Yeah, it's a question about trip counts. Where that data asking off the top of your head, that might be difficult to ask. I've got to say, the source of the data maybe and the base year may be more helpful to understand when that would be.
It does have pertinence because it was raised by highways that the trip count to and from the estate was low, and I don't know if that was ever resolved or highways were happy with the information with subsequent information. But it was definitely highlighted within one of the documents that the trip count to and from the site was low. So in effect, that would have an effect on potential NO2 readings from the development as well.
Yeah, yes. The question is the same, but with quantification about the traffic data and the trip generation from the highways evidence suggesting that the trips are low and the effect that has on NO2 in terms of the outcome.
So my specialism is not transport. That was dealt with by Dave yesterday, highways expert witness. But what I can reiterate is the fact that the air quality assessment was done on a quantum of 111 houses rather than the proposed 92. Therefore, the trip generation is robust for the level of development which is proposed.
In terms of the data source for the trip generation, what was that? Was that base year 2019?
So the proposed development generated traffic is for the opening year in 2026, but yet the model verification used a base year of 2019, and then in 2026 for the opening year.
Thank you. Thank you, Mr. Muswell. Sorry.
It's okay.
No, helpful, and it has covered some of the questions that I maybe have. I do have some questions to ask, but I will go through them, and things that have been covered, I'll seek not to repeat them, because I think there were quite a few pertinent points there that I was going to pick up in any case. So thank you for that contribution, Mr. Miskell. Before I do so, any other questions? There's no one else who's presented evidence, so we'll move to my questions. Firstly, we've gone to there's table 4.4, figure 4.1 of the assessment in core document 210, 10 receptor locations. We've already run through a lot of that. You've mentioned about it, the evidence and the methodology being agreed with the council, reference to their own monitoring data. The question and the design year up to 2026. The question that I have is that obviously we talked about the COVID-19 pandemic and the 2020-2021, which are effectively a blackout. We've kind of covered the fact that there's been restrictions on the A57, which presumably you said it didn't occur. It didn't occur in 2019, but it may have occurred to affect the 2022, the more recent data. I don't know, but we haven't had evidence to say it didn't. So whether there's an influence there, I just wondered whether the data sample, you're happy with the data sampling taking account of 2022, that 2022 is robust, or whether there are influences that call into question, and whether it should be that 2019 that should be the base year. That provides a more robust base year based on known factors.
Yes, that is correct. Had the 2022 data been available, we would have discussed with the pollution specialist officer whether they deemed that more appropriate, but we would have used a base year that they advised. But in this circumstance, 2019 is sufficient and robust.
My follow-up question to that has already been covered. It was about site-specific monitoring and dealing with the average, the sampling. The question really I've got in terms of taking some of what I've heard forward, some of the questions, is not so much in terms of the UK guidelines, which you've explained in terms of the annual average. Just for my understanding, can you explain your understanding of the rationale why it's done as a mean and why shorter term periods might not be the most robust method for monitoring, or whether is it a reason because it's more appropriate, the guidelines are more appropriate to address it in that way, or is it a feasibility issue in terms of monitoring and verifying the data in those shorter periods that were raised by in previous evidence?
Sorry, can you just clarify whether you're specifically talking about the monitoring?
Yes, it's obviously the particulate data comes from a model, so I'm assuming that potentially deals with the hourly. It's more about the annual average monitoring that may have been done, or shorter periods. Why they're not focusing on certain periods of the day? Is there a reason in your understanding why the guidelines don't do that?
The UK government has defined objectives which they see protects the general public from levels of air pollution. So it's considered that those averaging periods are what are considered a concern. So
in theory, they're looking at the consideration is more long-term exposure rather than sporadic peak moments that may be experienced.
So the hourly mean objective deals with those more sporadic periods. So that is an hourly mean. So for instance, some third parties have expressed concerns with peak traffic, so that's between 7 and 9 for in the morning, for instance. So that hourly objective would deal with peak emissions during those periods. But as explained previously, the air quality management area was not declared for the hourly objective, so presumably the council did not see that as a risk of exceedance in this area. Also, DEFRA also produces a annual mean level from research, which, if not exceeded, it is expected the short-term objective also would not be exceeded, and that's a level of 60 micrograms per metre cubed.
60 was that?
60.
Mr. Miskell, just through me, just a query, yes.
I'm led to believe that these diffusion tubes are not on constantly. They work intermittently. So if they're working intermittently, on off, there is the potential that during peak hour traffic, when the levels are at the highest, these tubes aren't on. And I've had that confirmed by environmental health, by people at council.
Right, I'll direct it because I did have a question about diffusion monitoring. Just your understanding of how those diffusion tubes work and whether they are selectively monitored or whether it's a constant approach and why the reason might be for one or the other.
So diffusion tubes are constant. They monitor every day of the year. The way they work is that they passively monitor concentrations, and the diffusion tubes are collected every month. So a reading is taken once a month. Unless the council don't collect a diffusion tube, then you would have readings from every day of every month.
So it's down to how often the collector and take a reading as opposed to the diffusion tubes actually doing it. So it's a discretion of the council rather than
no. So the council is obliged to conduct monitoring, and that should be for every month of the year for a diffusion tube. In their annual status report, where the monitoring data is obtained from, they will give a % of data capture, so it will be clearly stated in that report whether any months have been missed. But in the case of the air quality assessment for here, all data capture was, I believe, 100%.
Yes, and that's the difference then between the real-time monitoring where we refer to the contribution, where that could be looked into real-time monitoring, but the diffusion tubes are considered to be sufficient for the purposes of the monitoring that's required.
Yes, correct.
Is that okay, Mr. Miskell?
Yeah, it's just that maybe I've been fed misinterpreting information I got from environmental. I'm sure they stated that diffusing tubes were intermittent, we weren't operating.
Thank you. I can only take the evidence that's given by the witness. Yes. That's absolutely fine. I've put it to the witness, and the witness has given the professional opinion on that particular point. So I can only take that evidence that's before me. Thank you. We've dealt with my next follow-up because that was on the quantum of development, the finding of negligible impact. But you've already answered that question via a previous question raised by Mr. Miskell. I think you've already dealt with that question. I had one about pollutant concentrations at the primary school, but I think you tackled that head on in your evidence, and in terms of whether the assessment and background monitoring data is robust to find that long-term trends. Well, you've given a detailed explanation of the modelling, so I'm not going to ask that again. You've dealt with the average and the annual, so again, I'm not going to ask that again. Yeah, you've also dealt with the source of the assumptions on transport modelling, peak travel movements, and the cumulative effects of committee developments are included. So finally, mitigation measures. Just the understanding, in terms of mitigation measures, you've set out that the proposed development does not result in unacceptable increase in pollution concentration, and mitigation is not required to reduce the impact of the project to an acceptable level. However, the proposal does include some mitigation measures in the form of the travel plan. So that's core document 236, incorporating measures such as electric vehicle charging cycle provision, and also a financial contribution of £150 per dwelling. You've explained what that contribution may do, but just for my understanding, is the intention to provide that increased resilience? It's not questioning the robustness of the assessment. Is it a resilience factor rather than a questioning the robustness of the evidence in that respect? What's its purpose? That if you findings that there's actually no harm.
I was not privy to the conversation of the agreements to section 106 that was done by the applicant. And
you had no input at all in that, so that's a matter of judgment raised by, taken forward by the appellant.
Yeah.
All right, thank you for your evidence. We're now we're just past 3:35, 3:37, so we'll round it up and we'll take an adjournment now until 5 to 4. When we return, would you be happy to call your witness? Do you believe we've got enough time to proceed?
Yes, I'd be happy to call Mr. Tavendale, and without fear of contradiction, I don't think his evidence is going to require famous last words. I don't think his evidence will require a great deal of testing and cross-examination. I think it's reasonably clear. I don't think there's, certainly from the council's point of view, you can see their tree officer's response, and if there are questions of him, I'm sure we'll be able to deal with them quite quickly.
Okay then, in that case, I'll adjourn now until 3:55. If we can, when we return, if you can call Mr. Tavendale.
Yeah.
It's 5 to 4,
at the end of
so
the
it's time to resume the inquiry. Mr. Barrett, I believe you're calling your witness.
Yes, I thought Mr. Richards wanted to raise a
Okay.
timetabling matter.
No, not yet. Not at the moment.
Okay, fine. Well, sir,
Housekeeping at the end, sorry.
Yes, housekeeping at the end. I've
I've got the programme in front of me. I do anticipate
So we just do it at the
to
end.
discuss it. So
Yeah.
we'll talk about it at the end before we
Okay.
adjourn for the day.
so if you would have the proof of evidence of Mr. Tavendale, his rebuttal. There's an arboricultural impact assessment, 2.65, CD 2.65. The tree officer's comments, 6.22. I don't intend to refer to them, sir, but as background documents, you may want to have close to you, so to speak, CDs 6.9 and 6.11 that deals with the tree preservation order. That is the order itself and the objection that was made to it. Mr. Tavendale, let's begin by introducing you to the inquiry. From your proof of evidence as submitted, you're an independent arboricultural consultant operating throughout the north of England, 50 years experience within the industry, both as a self-employed contractor for 20 years and a consultant for 32. You have considerable practical experience in a wide range of arboricultural and silvicultural practices, and you're still actively involved in numerous management schemes involving trees within woodlands, development sites and garden environments. Your consultancy practice has a broad client base, and you're actively involved with many local authorities, developers, architects, planning consultancies, health authorities and legal practices. You're a member of the Arboricultural Association, International Society of Arboriculture and the Royal Forestry Society of England, Wales and Northern Ireland. In respect of this matter, you were approached by Wayne Holmes in April of this year to inquire whether you were available to review the survey work that had been done on trees and, as appropriate, undertake the inquiry on their behalf. You were provided with a comprehensive bundle of documents, you tell us. Your preliminary site visit was on the 15th of April. You joined a Teams meeting on the 25th, at which time the various issues, proposals, etc. were discussed, and you indicated that you had satisfied yourself that you believe the arboricultural proposals to be appropriate and that you were therefore prepared to act. Is that correct?
That's correct, yes.
I think we can treat much of the preliminary matter as read. You draw attention to the appeal proposal, you draw attention to the reason for refusal that cited trees. Is that correct?
Correct, yes.
You also reference the TEP impact assessment, which is CD 2.65, which I mentioned earlier.
Correct, yes.
Yeah. And you also mention at 7.2 on page 5 the tree preservation order, the objection made to it. The objections to it, and I don't think I have seen a response, but you may have, a response by the council. The complaint was that they failed to follow government advice and had not addressed how the amenity value had been assessed, taking account of the issues of visibility, impact and wider impact, all part of which is guidance. Is that correct?
That's correct, yes.
And they had included trees of low quality, and TEP had referenced them in their objection.
They had.
Have you seen a response to that objection?
No, I've seen no response whatsoever.
Would you go to paragraph 7.5 now of... you tell us there that from your own site inspection, you would also advise that in respect of the upper sections of the site, the order covers extensive areas where no tree material exists. As such, you consider the order is quite misleading.
Yes.
Okay. Now, the impact assessment. The impact assessment looked to canopy cover as opposed to individual trees. Is that an appropriate way forward, did you consider, for this site?
It is a way forward, and especially when you're dealing with areas of woodland and inaccessible slopes, what have you. It's a reasonable indication that can be used.
And if you go to CD, if I've got the number right, CD 2.65, that impact assessment, please. Go to paragraph 4.8, page 23 of 42 on the PDF.
Third page.
Hard page would be, let me just tell. Hard copy is page 20, page 23 of the PDF. So it's page 20.
That's canopy cover and tree replacement.
Yeah.
Yep.
The proposed tree removal is summarised in table 4. I don't think we need to look at it because it's summarised here. A total of very nearly 1 hectare. It's 0.9889. There's a degree of accuracy there that's
remarkable.
Remarkable, yes. 1 hectare of tree canopy cover would be removed to facilitate the development. References the pre-application discussions and the 2.2 for 1 replacement being desirable. That was interpreted as canopy cover, you can see at 410, rather than the count of individual trees, which would be largely meaningless. And then it goes on, the replacement strategy 412 and 413. The total amount of tree planting within the red line boundary is what this assessment compares to the target canopy cover replacement above. The planting that is proposed will increase in size from the point of planting until maturity. The assessment uses a 25-year period. See that? And then the forecast is at 414.
Yes.
And in terms, if you go to 418, based on the above calculation, and I don't think we need to go through the calculation, the proposed development will result in tree replacement at a rate of 101% by canopy area after 25 years.
That's correct, yes.
Yes. Now that's on site, isn't it? Let's be clear about that.
That's on site.
Yeah.
Including the construction of the road and all the associated planting up there.
And we know that in the course of the analysis in the officer's report, which you quote in your evidence, I don't think we need to look up CD 3.1, on page 6 of 8. You quote from it, do you not? 8.4, overall, the council's arboricultural officer objects to the proposal without further mitigation. Garden trees don't count. Street trees only count if the highway is adopted, which is currently not proposed. It is emphasised that a significant Section 106 payment agreement would be required to ensure the lost tree mitigation is recreated elsewhere in the Glossop area. Do you see that?
Yes.
And overall, the planning officer recommended approval.
Yes.
Yeah. Would you go then to section 10 of your evidence? It's a summary of conclusion of this section. The on-site works, as we've seen, is more or less a 1-for-1 replacement.
Yes.
The summary and conclusion section is that in addition to that, if I've got this right, there will be at 10.11, your paragraph 10.11, there will be, in addition to the 1-for-1 replacement, financial contribution in respect of tree planting by the council, £72,000 for planting,
correct,
and an additional in round figures of £20,000 for future maintenance.
Yes.
Is that correct?
Correct.
And that will be obviously in addition to the 1-for-1 replacement.
Correct, yes.
Can I ask you then to turn briefly to your rebuttal? I know it was prepared on the basis of a response to Mr. O'Brien's position, is that correct?
Yes.
At 3.2, you actually address the rationale for the 2-for-1 replacement, do you not?
Yes.
That rationale is the significant failure rate that's presumed in the written justification requires 2 for 1.
Yes.
What's your experience? You explain it at 3.2. What's your experience of that failure rate?
As I say in the rebuttal, I think it's a very poor reflection of the work when it's done correctly. In my own experience, I'm not sure we could actually have stayed in business if we had had a 50% failure rate and had to go back and replant on each occasion. So the success rate, I would say, would be considerably higher than that.
You express it in your evidence, I think, at about 90%.
Yes.
Or at least 90%.
90%, yes.
And is that your experience?
Yes.
And you tell us at the very start that your practice is based in the north of England.
Mm-hmm. Yes.
And so are you taking into account climatic conditions?
I would expect the same. It doesn't matter whether you're talking north or south, because you pick the right tree for the right location. So whilst you might have some more sensitive trees that you would plant down in the south, up here you would pick hardier trees that were appropriate and from the correct provenance. So you would expect a very good success rate.
Okay. And I just want to have a look at, I don't think we need look it up, policy EQ9, which is the tree policy that is being referred to.
Yes.
For the inspector's note, it's CD 4.7, paragraph 5.76. The policy isn't an absolute mathematical requirement for a 2 for 1 replacement, is it? It
No.
talks in terms of being where appropriate and where possible.
Yes.
And in terms of applying the rationale in this particular case, if you have achieved 90% there or thereabouts success rate,
yes,
you've got a 1 for 1 excuse me, on site.
Correct.
And you've got a 72,000 contribution off-site and achieving about a 90% success rate. In broad figures, almost anecdotally, if I may ask you, Mr. Tavendale, is that better than what is going to be lost?
I consider, yes, it would achieve a very satisfactory result.
So if one was to ask the rhetorical question, would there be an arboricultural benefit, disbenefit, or whether it would be neutral, what would be your answer?
I would like to say there'd be a benefit, because you'd end up with the right trees in the right place, well planted and well managed.
Yeah. And there are obviously conditions proposed, and the sum to be given to the council is for them to achieve that.
That's correct, yes.
Okay. Well, thank you, Mr. Tavendale. Those are my questions of you in terms of dealing with the tree issue.
Thank you, Mr. Tavendale. Is there any questions from interested parties? Mr. Miskell, through me, please.
We're talking about replanting off-site, and that would be benefit. Am I correct?
I'll relay the question because we've got a problem with the mic. So the question is, are we referring to replanting off-site? Is that correct or not?
There is replanting included off-site as well as on-site.
Just to assist my understanding, which components are we talking about? Is that the financial contribution to off-site and
that's my understanding.
The division between the two.
That it would be the off-site.
So, to assist me, I'm just taking your question forward, Mr. Miskell. When you're saying the 101%, is that on site or does that include the? Does that include
my understanding that's on site.
And then the off-site planting additional.
Yes.
Does that answer your question, Mr. Miskell?
Yeah, I mean, the off-site, you stated would be beneficial, a betterment, but is it a betterment for the residents of Public Waste and those who reside on Dinting Vale? to lose so much woodland, a valuable amenity.
I'll take the question, but I'll rephrase it. So the concerns are the effect, whether it's betterment for residents on Dinting Vale, with specific reference to the off-site planting. You did just confirm to me that the 101% was on-site. So whether you can quantify your answer in terms of the effect for people on Dinting Vale and the fact and to assist me in terms of the additional quantification, what the policy how it relates to what the policy requires. I believe Mr. Barrett raised policy EQ9, if I'm correct. Just place it in that context in terms of the impact Dinting Vale and asking the question, and then meeting the policy requirements and what it expects and what it allows for.
We will get virtually on canopy area 1-to-1 replacement on site. Off site, I do not know, and possibly the council do not know at this point in time, where that off site planting will occur. So I can't genuinely say whether that's going to be of immediate benefit to the people living within proximity of the proposed development, or whether that benefit and that improved environment is going to benefit other people.
Yes, and in terms of the policy compliance, Mr. Barrett drew attention to the where possible.
Yes.
Caveat. So in that context, do you consider the development is doing what's possible, at least what's possible?
Yes, and I understand that's what the planning officers agreed.
And just for my question, just continuing a little bit, the disagreement between the council officer in terms of the interpretation of inclusion of street trees, etc., and the difference of view. Can you just explain your position in terms of whether you think that those are included and whether they are included in that 101%?
Sorry, the offsite, Sorry, can you repeat the question?
Sorry. The question is about the disagreement from the arboricultural officer, the council's officer, where they excluded a number of the trees within the site, and there seemed to me to be some disagreement. So just understanding your view on
right.
that.
Yes, he felt that trees in gardens and trees on unadopted highways shouldn't be included within the calculation. But as I indicated in my proof, many trees protected by preservation orders, and normally a preservation order is placed on a tree because of amenity benefit. Those are frequently, I won't say predominantly, but certainly frequently in private gardens and possibly unadopted highways. Because, of course, trees in highways and trees in public parks and what have you, because they are under good management by the local authority, they are not. The guidance says that they need not be protected because they're under good management. So it's to ensure all the other trees in gardens, private roads, whatever, they're also protected by having a preservation order put on them.
Thank you. Nothing further, Mr. Miskel, are you happy with the...
Yeah, I'm not happy with the idea of placing trees in gardens on footways in the gardens itself. Because at some stage, they're going to grow. And the tendency is, and we're talking about family homes here, not space. They will argue that it's blocking light. The neighbours will argue they've got leaves all over the garden. So at some stage, they come down. You can see it on any development up and down the country, and area where I used to live used to be full of cherry trees. Blossom was beautiful in the spring. Within a 5-year period of new residents moving in, didn't like the idea that the trees blocking out the line do get cut down. You know, and we're talking unadopted roads, so, you know, I would imagine people will take them down. But interestingly enough, the comment was made this morning regarding the gradients as regards the footpath for disadvantaged people of impaired mobility, that the footpath would be able to extend it and more, make it more like twisty-turny to reduce the gradients involved. But the downside to that would be a significant amount of trees would be removed to accommodate that path or that plan. So when you look at the site, and you're talking about a one-to-one replacement of trees, 90% of it's going to be concrete or tarmac. So I can't see where you want to put these one-for-one trees.
I think what you're referring to there, Mr. Miskell, is it was an option that was discounted in terms of the civil engineering. As far as I understand it, from the evidence that Mr. Nicholas presented, it's included within the proof as an example of what could be done to achieve the footpath gradients within the site to get the level of access that would be sought by the guidance, notwithstanding the flexibility that's therein. It was a discounted option, and it was a discounted option on the, as far as I know, on the basis of woodland impact. But I'm not sure the extent to which Mr. Tavendale would have been included in that decision, because I'm assuming it may have been prior to his appointment or undertaken separately from the civil by the civil engineer. Mr. Tavendale, are you aware of?
No, that was prior to my involvement.
False. I would imagine false involvement.
No. That's not, the dates have been given from Mr. Tavendale's involvement, and my assumption is that it was defined. So
April this year.
It's a matter of judgment in terms of the impact on removal of additional trees to facilitate that option, why it was discounted. But because it's not part of the proposal, my assumption is that it wasn't put to you, Mr. Tavendale.
No.
Okay. So I can't pursue that any further with the witness.
Just as a matter of interest, what is classed as a low-value tree? I would imagine any tree has value. It supports an ecosystem. It supports an environment. It provides foraging area for local wildlife, a food source for local wildlife. Regardless of what species it is, it's part of the ecosystem. So what is a low-value tree?
The question is about a low-value tree. My assumption is there are. You can quantify that there are British standards. That's my awareness, and the arboricultural assessment was undertaken in accordance with those British standards, which include specific criteria for assessment of conditions of trees in terms and the value.
That's correct. Yes, it is in trees in relation to construction. Or development, demolition, etc. But yes, we have to provide a classification for the tree, and that is based on its quality, its future potential, its size, etc. Yes, of course, a tree, any tree, even a dead tree, can have value, but one has to start putting a sort of a judgment somewhere in the equation, so that if trees have to be lost for any reason, you can start assessing which would be the least valuable trees to remove.
And it's a professional judgment based on specific standards that dictates things like stem diameter, for example, expected longevity, health of the tree in its particular form, etc.
Yes.
And my understanding, and that from referring to the evidence, so to just qualify for the benefit of Mr. Miskell and anyone watching at home, is that it's permitted to undertake such an assessment for both individual trees and groups of trees, depending on the ability to access and do so. And the number of trees within the site and its gradient makes it very difficult to have an accurate tree count, which was one of the reasons why it's suggested that canopy cover is alternatively used.
And it's not unreasonable also to consider that a woodland can exist in its own right and should be considered in its own right rather than the individual elements within it.
Thank you. One more, Mr. Miskell.
Do trees have to air quality? Do they improve air quality? Do they sustain? Do they absorb pollutants?
Right, it's a question about the trees, whether they absorb air pollution and whether they have an effect in that regard.
Certainly. They're of major importance in towns and cities to assist in controlling air quality. And that fact has been known for a long time.
Just taking forward Mr. Miskell's point on that, just for clarification, is there likely to be effect in that time period while the trees mature in terms of the replacement?
A very interesting question and a very difficult question to answer, because of course a young vigorous tree that frequently is producing a mass of leaves of a greater size and with greater vitality probably might be contributing more to air quality than an old tree with small leaves, low vitality, and possibly even a sparse crown. So, you know, it isn't providing such a good filtering effect.
Thank you. I'm assuming there's nothing further, Mr. Miskell?
It's just a thing to know. It's not actually a question to
very quickly.
So, by removing trees, we've now established that there will be a drop in air quality. The ability for the woodlands to soak up airborne pollutants has been reduced. By what margin, I don't know. But we're looking at a woodland which sits aside an AQMA and must have a calming factor on those levels. So by removing those trees, in effect, there is a potential for those levels to rise, and surely that should be factored in on the environmental assessment as we can say air quality. But here we are in an AQMA, and we've got a perfect sponge to absorb the pollutants, and we're taking it out. Plus the loss of visual immunity and the effects on BNG.
Thank you, Mr. Miskell. Because it's not in the form of a question, I've heard the point, but I can't necessarily frame it as a question other than reframe it for myself, which is just.
Can I rephrase it as a question then?
I think I'm okay to rephrase that question. I've got the point. I understand the point that you're making there, and it's a point that links to points that you've already made at this particular point. So, I think it's my time now to rephrase that in the form of a question to take the inquiry forward. Can I ask you not to interrupt me, please, Mr. Miskell? And I am speaking here. It's now time, I think, to just take that point forward. I understand your concerns with air quality, and we had a lot of questions about air quality. I understand the concerns about the links with the loss of trees. To assist me in the inquiry, what I need to understand is what, from Mr. Tavendale's perspective, and understanding he's not an expert in air quality matters either, and there isn't any specific data before us of the effects potential before and after. I don't have that evidence, and I'm assuming there isn't any evidence on that particular point. No, that's the point. So it's just my understanding, and it's from professional experience rather than any specific data that we're relying on or even assertion. Just in terms of those effects, in terms of the maturing, where you've drawn out the point that a young vigorous tree that may replace a tree that isn't performing quite as well in terms of that air pollution. What the kind of lead-in times would you be looking at from plantation to kind of achieve that effect? I don't know, it may be species dependent, but typically when would you start to see those kind of benefits accrue?
Well, from a level of 0, with a road that has been constructed, trees have been lost, those plants will be working from day 1.
So from day 1, and the effect may increase as it matures.
And the effect will increase from that day onwards.
Thank you. Unless there's anything specific, Mr. Miskell, I'll close the floor at this particular point and just check whether I've got any additional questions to cover. First quick question was just on the status of the tree preservation area order. We've covered it quickly. Just, is there any update at all? The fact you've not received a response.
We've received no response.
So it is on the basis of the evidence before me. The council's made it temporary. There's no update in terms of whether there's an intention to make that permanent, and there's a standing objection to it.
And I think my comments will be blatantly obvious to you, so when you go on site at your own inspection.
Yes, I have read the comments. I am familiar with the site, so I've seen it via walking through the footpath. So I have made my own observations already, but I will be doing again as part of a site visit. There was one comment that in paragraphs, I think it was 6.4 to 6.6 of your proof of evidence, where it's talking about tree conditions and the effect of the proposal on the retained treescape, where you say the management to retain trees taken together with replantation would ensure that the retained treescape is improved and enhanced. Is that taking account of the fact that there's the presence of a road? Is it because of the increased tree cover over other parts of the site that's kind of offsetting that effect in your
Sorry,
opinion?
Which paragraph was that?
I think
again?
it was paragraph 6.4 to 6.6 of your proof.
Right, so I said in 6.6 that tree losses will be caused by the proposed construction, but it has been indicated that by the imposition of conditions, management can be implemented to retain trees, which together with replanting will ensure that the retained treescape is improved and enhanced.
Yeah.
Because just for a tree preservation order to be served on a site means no work can be carried out other than the removal of dead wood without consent from the local authority. That's the only effective control the local authority has.
Yes, so by virtue of putting a TPO on, it may reduce the ability to manage some of the existing trees. So,
yes.
So what you're saying is the removal of the trees and replacement and additional management associated with that's forming that view on retained treescape.
That's getting management conditioned on them, if you like, and that will be a positive move.
Right, I did have a question about the one for one, etc. But yeah, I think you've already covered that. You've already covered the question that I had in terms of the woodland mix and in terms of the rebuttal. In terms of the 90% success, the question drew out some of what the questions that I had in terms of what formed your view on that. I don't proceed to take that any further. And you've also I've already asked my question about street trees and in-plot planting, so I've already obtained that. So I have no further questions, Mr. Tavendale. So I thank you very much for your evidence. Thank you. Okay, moving on to housekeeping and starting with, we'll start with the programme. So, Mr. Richards, I believe.
Yes, so I was just mulling over the programme. So,
Yes.
And so far as tomorrow is concerned, we can now tick off Mr. Tavendale as
Yes.
having done him this afternoon.
Okay.
So that leaves ecology. And from experience to date, that half-morning session is going to be more than adequate, I would assume, for ecology.
Yes, I'd hope so.
We've broadly managed that so far during the inquiry, and I say no reason to be more pessimistic than we've been to date.
Yeah, half day, you say, rather than...
No, well,
yeah.
We've got half a half day. We were due to do 2 witnesses tomorrow morning.
Yes.
So on that assumption, we ought to do 1 witness.
Yes.
Pretty much before the break.
Hopefully, yes.
Yeah.
With a fair wind, yes.
Yeah. Then my suggestion would be, because we know we cannot bring forward Mr. Heathcote.
Yes, true.
And we know we cannot bring forward conditions and planning obligations.
Yes.
That we should bring forward Mr. Hurrigan.
Okay.
Now, I know that the planning witness likes to sweep up.
Yes, they do.
If there is any sweeping up to do after Mr. Heathcote on viability, then of course I would have no objection to him being recalled to be able to deal with that. If during third interested party or your questions on viability, Mr. Heathcote said, I don't know, we'll have to ask Mr. Hurrigan, then of course Mr. Hurrigan should be allowed to do that on Tuesday. But for everything, all other sweeping up and planning policy matters and so on and so forth, it seems to me that we ought to ask, in the interests of making efficient use of inquiry time, Mr. Hurrigan to do that tomorrow. That would then leave us on Tuesday, and then after that, you would be free to do whatever else you wanted to do on Thursday afternoon. We know that you were due to visit the school drop-off observation. I don't know whether you still need to, and I don't want to ask you to declare publicly whether you are intending to do that. It could be a bluff or a double bluff or a triple bluff.
I'm not declaring publicly whether I am or not. It is in the programme.
Yeah, absolutely.
But I have been quite clear it's within my gift if I choose to do so or not.
So if we did all of that tomorrow, and I think there'll be plenty of time, that would leave us on Tuesday to do Mr. Heathcote on viability, any sweeping up from Mr. Hurrigan, and then the roundtable sessions on conditions in 106.
Yes.
I think that would also leave time for us to do the closings on Tuesday.
Okay.
And then we wouldn't have to worry.
I'm saying okay in terms of I understand your view rather than...
I may be wrong, and that come Tuesday we find some compelling reason to do them on Wednesday morning by teams. But I think with a fair wind, we ought to be able to draw matters to a close here on Tuesday. That's my submission to you.
Mr. Barrett?
So, 2 points. The first point really is a concern that I've expressed throughout the course of the inquiry. I would want the public to be able to feel comfortable that they've had a full opportunity to address you. And I do that both out of my client's own self-interest because it's important, and it also may have, and I put it no higher than that, legal implications. The programme is in the public domain. If people are looking forward, and I use that term in the widest possible sense, looking forward to challenging planning evidence, they're expecting to see and hear that on Tuesday, and with the best will in the world, if we now put it on the web page, they've got half an hour of normal inquiry business today, and they know that they'll probably take the morning or half a day tomorrow to deal with ecology. So I do have a concern there. So quite frankly, that is my principal concern. In terms of the presentation of my own case, then I would always prefer to call my planning witness last as the sweeper. But I accept that Mr. Richards is being constructive in saying I would have the opportunity to deal with that out of turn and recall Mr. Hurrigan, as I understand it, in the event that something was thrown up during the course of Tuesday morning when viability evidence was given. So I don't want to appear difficult or unreasonable. I can see there's a big gap in the diary, and it tightens up then on Tuesday, because if I'm calling 2 witnesses and Section 106 and conditions, that's a pretty heavy day, I would have thought, and then if we had closings, even heavier. But that is a concern that I have, and I, quite frankly, on balance, would prefer to not tempt fate and just deal with the consequences of Miss Kerr's evidence being completed tomorrow, and at that point, if you've got no other business, adjourn. But sir, I don't want to appear unreasonable. I can see the force in what my learned friend is saying. I just hesitate because of where we are in terms of the contribution from members of the public and whether they have an interest in hearing Mr. Hurrigan. I can't predict what that interest will be, but I know planning was, if I can say this, a controversial issue amongst a number of residents. Now, whether they will turn up or not, I simply have no idea.
So can
I think yes, I'll let you respond
the published programme is quite clear. Mr. Hurrigan's name has a big asterisk against it, and there's a quite clear in footnote 1 that means items which could be brought forward or pushed back dependent on progress made. Yeah. We have made progress, and Mr. Hurrigan should be brought forward, and that's perfectly clear and in the public domain, and no possible unfairness could result. The public, if I may say so, sir, have been given ample opportunity by you. I do not think anybody could complain that they have not been given the opportunity to say what they want to say. That included by bringing forward Mr. Tavendown. And I see no reason why the same should not apply to Mr. Hurrigan. This inquiry has made, in effect, expanded into the time available. In other circumstances, in my professional experience, we could have made swifter progress, but we've made the progress that we've made. And I'm simply keen to ensure that we do not go into Wednesday where it seems to me that with sensible use of tomorrow, that can be avoided.
I hear what you're saying. I hear what you're saying in terms of bringing Mr. Hurrigan forward. I hear what you're saying about efficient use of time. I do have concerns that it's relatively short turnaround on effectively the sweep up issues where there is no council testing of that evidence, so the inquisitorial burden will be on me, and there has to be a fair opportunity for interested parties to comment. Now, after all I've heard so far, I appreciate the concerns in terms of time savings. There are potential time savings, I believe, if we do not call Mr. Hurrigan tomorrow, on the basis that I will be able to work in providing my comments on the draft planning obligation in the time that's freed up, which should then acquire some cost savings in terms of the roundtable discussions on the planning obligations, because we can focus it to a very tight list of questions that I will then have. So I believe that's my preference. I think there was an asterisk in there. I accept that. it probably hasn't worked in my favour, it being there, because the asterisk was really there to suggest that it could be brought forward in the session to move forward if viability was dealt with earlier.
Yeah.
I'm not entirely comfortable with bringing the planning witness forward because of the potential for
That's
for
fine, sir.
concern.
I made my points. You've made yours, and it's your inquiry.
Yes. No.
So don't worry about that, please.
No. That's absolutely fine. But I can assure you that I will use the time productively to try and save some time in the roundtable sessions.
That's
and
fine,
if
sir.
if there is any possibility of us closing on Tuesday, I won't hesitate. But I'm also not going to be beholden to time constraints to try and achieve it either. If it's not possible.
No, I understand that, sir. And in order to, and in that vein, you will see that the 106 and its attachments are uploaded on the website as Inquiry Document 9. I have a hard copy of the 106. You've had the attachments in hard copy, I think, previously, so we haven't got those available, but they are available on the website. So here is the hard copy of ID 9 that we promised you.
Thank you. Thank you very much.
Hugh, does the inspector want us to put on our website now that it is likely that Wednesday will be held remotely?
Yeah. Yes, just a query. Do you want us to say anything now on the website about the potential use of Wednesday for closings?
I think in terms of the virtual use for closings, it will be down to me to publish a draft, an alteration to the draft programme.
Okay,
so I will have to modify that and make sure that it's sent through via our case officer through to the parties for it then to be uploaded on the inquiry website. But that will confirm that Mr. Tavendale was taken this afternoon by agreement during the inquiry. It will confirm that the ecology witness is brought forward to the first item of business tomorrow morning, and that the sessions in the inquiry this week will close at the end of the ecology witness tomorrow.
Yeah.
Thank you.
Fine.
We'll sort out a mic, will we, for the...
Have we asked them?
No, I haven't asked them.
Anything further on housekeeping before we adjourn for the day?
No, not for me. Thank you very much, sir.
Thank you. The time then is 4:42. The inquiry is adjourned until 10 a.m. tomorrow. Thank you very much for all your contributions today.